Would your side any mentioning?
Milord, may I have your lordships kindly?
Yes, Mr. Chatterjee.
Yes, an appeal is not in my lord's list.
Seeing you after a decade, I think.
It is rather.
That's because I'd become a criminal.
My lord, I'm appearing
It is
on
my
behalf of the
misfortune, in fact.
Yes.
Not met. Milord, I'm mentioning an appeal not in my lord's list. The appeal is ready for hearing. Paper book has been filed. Milord, some urgency has cropped up because the main suit, which is a commercial suit now, having been transferred to the commercial division.
Mr. Chatterjee, give the slip, ask your junior, it will be listed immediately. Normally, we call on the list,
Yes.
and whoever is ready can start. And once we start hearing an appeal,
Yes.
it has to be completed.
Yes, Milord. I'm obliged, Milord. Only thing is that the suit has again been fixed by the learned single judge on Monday. And on the last occasion, the learned single judge expressed a desire to proceed with the suit, irrespective of the pendency of the appeal, unless there is a specific order of stay.
It will be listed tomorrow, and let us see.
Well,
Then it'll. Yeah,
If it is listed tomorrow,
yes. So long as the papers are available, dekhe na.
Lordship, leave you.
Appellate side mentioning. Appellate side non-commercial matter, item number 1.
चलो नहीं तो কেন এসছি to be mentioned? এটা assigned.
Item 2. Sorry, item 3.
चलो defective जागे चलो.
Item 4. 5. 4.
Yes, pass over. The respondent is not there. Pass over.
Yes, it's only short pass.
Five, Mr. Ghosh.
5.
Your lordship was
First call, pass over.
Pass over.
no.
This our bad habit of sitting at 10:30 creates problems for.
No, what is creating really the problem is from my place to town hall, 10 minutes.
Oh,
From town hall to 6 Old Post Office is my chamber, 30 minutes. If I come, I start after 10.
Plus, Mr. Ghosh has a very big car.
I see.
Also,
It's a ship.
It's a ship.
it's a ship.
It's not a car.
It's a
Now, what is it? What brand is it?
Toyota Fortuner.
Fortuner.
It's a ship.
Fortuner, possibly. Or unicorns are extinct. Very well. Pass over.
Item number 7.
পুরোটা ডাকো.
8. 9. হচ্ছে না? 10.
Chain, I beg to appear on behalf of the petitioner. My lord, in this matter, I will be seeking a liberty from this honorable court to serve upon the learned advocate for the state. Why I am seeking this liberty? Because this is a review application. We tried to serve upon the learned advocate who was appearing in the appeal. But he told us that now he is not appearing. You have to serve unless until there is a direction.
Serve. Let the review applicant effect service on the state
A learned advocate for this state.
On the learned
Who
advocate.
appeared in the memorandum of opinion.
On the learned advocate for the state who represented the state in the appeal, and let affidavit of service be filed on the next date. Paragraph lists this matter once again. Next Thursday date the other.
লিখে দেব। Appearance to them, appearance to them, appearance. 11,
Next.
12,
Order has been all passed.
But for the petitioner,
Sure.
the order has been complied with. We'll dispose it of. Very well. Learned advocate for the petitioner says that the order, comma, violation whereof is alleged in this contempt application, comma, has been complied with by the respondents. Stop. Paragraph, in that view of the matter, CPA and such stands disposed of.
Thirteen, 15, 16, 17,
Second call.
passover matters. Item number 1,
Not today.
item 3,
Lordship, this is my appeal.
What is the defect? The cause list says it's defective.
Against section 17.
It's all very well, but you have to remove the defect first.
See, the
Just see the note of the stamp reporter. See the note of the stamp reporter.
defect.
Yes.
Yeah, the defect. Oh. Deficit code fee. There is a deficit code fees of rupees 400.
Yes.
Conducting, I'll put it in today. By today, I'll put it.
Very well. Undertaking নিয়ে নেবো। Yes, দাও কাগজ দাও। Have you served?
This is actually what happened. Unilateral appointment of an arbitrator, that too without jurisdiction. There is a clause in the agreement. Contract, this is a finance contract, a loan agreement, entered into by the appellant with the bank at APJ House, Calcutta.
So all very well. Ex parte interim order has been obtained
Yes, ex parte interim order, and kindly see, not only
in a section 17.
17, and kindly see how they have conducted. Every day we are trying to connect, writing letters, please let us know. Everything is being done by email. Nothing is being served. Everything is done by email. And all of a sudden,
No, Mr. Sir, this is 29th March.
Yes.
We are in June. Serve and come back.
I'll serve.
Serve.
Because they have not implemented now still yet. Because they know there is a jurisdiction issue. The clause says the arbitration would have to be in Calcutta at the branch office. And kindly see the arbitration clause, Your Lordship, shocking. 10.15 at page 27. Even if I assume this is an arbitration clause, it is a unilateral appointment.
Where will you come and sir, when will you come back? When will you come back?
I'll serve. I'll come back next week. I'll come back
Monday, Tuesday.
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 Or Thursday. Keep it Tuesday. Keep it. My lord, keep it on Thursday just to be on the safe side.
The appellant undertakes to pay the deficit court fee and remove the defect as noted by the stamp reporter in course of the day. Stamp reporter, comma, in course of the day. Paragraph, let service of the appeal papers be effected on the respondent and affidavit of service be filed in court on the next date. Paragraph, as requested by learned advocate for the appellant, comma, let this matter be listed again on Shamne Brishpotibare date diye dao, retaining its position.
Compelling circumstances that a notice for mentioning was given. I got stuck in the elevator, my lord. My lord has been
Follow some discipline, Mr. Bhattacharya. You are a senior counsel now.
to be
You are a senior counsel now. Do not mention once the list has been called on. You will set very bad example for the juniors.
difficult.
Call the next matter.
Item 4,
Item 4, Your Lordship, I beg to appear for the appellant. If Your Lordship remembers, this is the 5 and 8 matter, Your Lordship. Kindly peruses the last order. On the last order, there was an order of deposit upon them to deposit
Yes.
1,75,000, Your Lordship.
What is it? Is it a auto rickshaw? What is it?
No. It is a vehicle, in as much as I am aware of, Your Lordship.
Is vehicle, we remember, auto rickshaw isn't a vehicle.
Auto rickshaw is a vehicle, but larger vehicle than auto rickshaw, probably, Your Lordship. I have to show you, see, Your Lordship.
Demand draft or banker's check for 1,75,000.
Apologies, my lord.
No.
Right order has been complied, but my lord, I'm very sorry to say that my lord, respondent did not follow the order.
Your client would not follow the order. Then he will suffer the consequences. What can be done?
Absolutely.
What about the order, your lordship?
So what should be? Do you take possession?
Because if Your Lordship directs the jurisdiction and police station to send the vehicle, possession of the vehicle, and we'll proceed with the sale.
Yes.
We'll proceed with the sale of the vehicle. And in accordance with, like, there's a loss and sale, we'll proceed in accordance with the Arbitration and Conciliation Act. It's a truck, Your Lordship.
Truck. So we'll dispose of this application.
Yes. That's the Lordship deems fit. The only thing is the vehicle is in our possession. Then
You
jurisdiction.
take possession.
Yes.
Acha. Dekho. Oh, your section 8 was dismissed.
Yes.
That is why the appeal.
Yes.
I see. Where is the arbitration agreement?
The arbitration agreement as well.
Because we have to set aside that order.
Yes. The agreement has to be shown, Your Lordship. I shall. It is as page number. It starts at page number 125. From the arbitration clause content. Lordship, the arbitration clause is at page 137 of my stay application, Your Lordship.
Who filed the suit? You filed the suit.
No, no, it was their suit.
They filed the
They
suit.
filed the suit. This
Why
is the
did they?
general-
What did they ask for in the suit?
They have asked for mandatory injunction. This is the usual practice.
Mandatory injunction.
To not us for us. He has said in this suit specifically that we are trying to siphon off the vehicle. We are doing this and all, which is absolutely concocted submission. They generally make. This is a general practice, Your Lordship. If Your Lordship pardons my language, this is a general practice that they file a suit just because to stall my arbitration in proceedings, Your Lordship.
Hey, লেখো তো। This appeal is directed by consider the parties. This appeal is directed against a judgment and order dated January 3, 2025, passed by learned
Sixth bench, Your Lordship.
sixth bench,
City Civil Court.
which sixth bench where?
City Civil Court at Calcutta, Your Lordship.
City Civil Court at Calcutta, in title suit number 1487 of 2023, whereby the application of the present appellant under sections 5 and 8 of the Arbitration and Conciliation Act, 1996, was dismissed. Stop. Paragraph. Briefly stated, the relevant facts are that the respondent entered into a hire purchase.
No, it's loan cum hypothecation agreement.
Entered into a loan cum hypothecation agreement with the appellant company in respect of a truck. Stop. The respondent started plying the truck commercially. Stop. Installments having fallen due, naturally the appellant demanded payment from the respondent. Stop. The respondent filed title suit number 1487 of 2023, inter alia to restrain the appellant herein from repossessing the truck or interfering with the plying of the truck by the respondent. Stop. Paragraph. The agreement between the parties contain an arbitration clause which reads as follows. আমি জানি না তুমি পড়তে পারবে কিনা, আমি খুব কষ্ট করে পড়েছি, page 137. Clause 30.
Clause 29, Your Lordship.
29. দেখো, না হলে আমায় বললো, আমি পড়ে দেবো. Set out.
Apologize, Your Lordship.
Paragraph. In view of the said clause, comma, the appellant herein applied before the learned suit court, learned trial court, under sections 5 and 8 of the Arbitration and Conciliation Act, 1996, for reference of the disputes forming the subject matter of the suit to arbitration in accordance with the aforesaid arbitration clause. Stop. Paragraph. By the impugned order, the appellant's application was dismissed. Stop. The learned judge noticed that earlier an arbitral award had been passed in favor of the appellant, but the same was subsequently set aside by the competent court. Stop. Thereafter, proceedings, interlocutory proceedings are pending in the suit. Stop. Noting the same, the learned judge was of the view that it will not be appropriate to refer the parties to arbitration. Stop. Being aggrieved, the finance company has come up by way of this appeal. Paragraph. The order under appeal must be set aside. Stop. When there is clearly an arbitration clause in the agreement between the parties and disputes have arisen in connection with such agreement, the trial court had no option but to refer the parties to arbitration. Stop. The question of it being appropriate or inappropriate does not arise in view of the language of section 8(1), 8(1), which is mandatory. Stop. Section 8(1) is set out here under paragraph. It would appear from the language of section 8(1) that unless the court or the judicial authority concerned finds that prima facie no valid arbitration agreement exists, the judicial authority / court would have no choice but to relegate the parties to arbitration. Paragraph. In the present case, we have set out the arbitration clause above. Stop. It is nobody's case that the said clause is not an arbitration clause. Stop. In that view of the matter, the appellant's application under sections 5 and 8 of the 1996 Act must be allowed, and we allow that application upon setting aside the order impugned in this appeal. Paragraph. When this appeal was first entertained by a coordinate bench, the bench, by an order dated March 6, 2025, had directed the respondent to pay a sum of rupees 1.75 lakhs within 3 weeks from date without prejudice to the rights and contentions of the respondent, comma, noting that installments had fallen in arrear. Stop. Thereafter, comma, from time to time, the matter was taken up for hearing. Stop. Paragraph on April 22, 2025, the respondent, 25, when the matter was called on, comma, nobody appeared for the respondent. Stop. A coordinate bench directed service of notice on the respondent. Paragraph. By an order dated April 29, 2025, a coordinate bench had directed the officer in charge of the jurisdictional police station to secure the presence of the respondent before the bench on the next date, i.e. May 13, 2025. Stop. Paragraph. However, on May 13, 2025, the bench was not available. Stop. When the matter was again taken up for hearing on May 14, 2025, learned advocate for the respondent apprised the bench that the respondent had appeared in person on May 13, 2025, but the matter was not called on. Stop. He submitted that the respondent is serious about paying the dues of the finance company and sought for some more time. Stop. To test the bona fides of the respondent, the coordinate bench had granted him one more opportunity and had adjourned the matter till June 11, 2025. Stop. It was directed that on the adjourned date, the respondent shall bring a demand draft / banker's check for rupees 1,75,000 drawn in favor of the appellant. Stop. The respondent was also injuncted from disposing of or alienating or creating third-party interest in respect of the vehicle in question till further order. Stop. The interim order that was passed on March 6, 2025 was also directed to continue until further orders. Paragraph. Today, learned advocate for the respondent says that the respondent has not complied with the order for payment of the sum of rupees 1.75 lakh to the appellant. Stop. Learned advocate fairly submits that appropriate orders may be passed by the court. Paragraph. We confirm the interim order of injunction passed on May 14, 2025, and also the interim order March 6.
6 March.
No, also the interim order 2025. Stop. The appellant will be at liberty to take possession of the concerned vehicle. Stop. The jurisdictional police wait for us to complete.
Your Lordship. I apologize, Your Lordship. I cannot control my exuberance at times.
The officer in charge of the jurisdictional police station is directed to render all assistance and extend all cooperation to the appellant's officers to repossess the vehicle in question. Stop. That is all.
That is all. And in accordance with law, we shall take steps. That is
The appellant will naturally be at liberty to take steps in accordance with law for recovery of its dues from the respondent.
deeply obliged.
Paragraph, the appeal and the connected application stand disposed of.
Deeply obliged, Your Lordship.
Item 5 with 6.
We have prepared the convenience compilation. Double to the circle.
Yes.
Now, okay, now. Está, ¿cómo es que no? My learned friends, juniors, have tried their best, my lord. Kindly look at the index.
Yes.
Mention the relevant portion or the clause or the portion of the pleading, award, etc. That is the particulars. Then volume number and page number of the paper book, and page number means page number of this compilation.
Very well.
But as usual, this is my bad habit, my lord. There is, your lordship will kindly come, my lord, item number 8.
Yes.
Reading in SOD, a wrong page has been included. It should be,
Serial number 9.
serial number?
Quantum of work done by as per state.
Yes, sorry. Para 9.
Page?
Para 9.
26 of the volume, it should be 246.
246.
But the page which has gone as an extra is 226. That has to be
Kindly come to page.
Page 14.
Very well.
246.
The wrong page has gone. ওটা আগে দেখি
Volume 1.
Volume 1. Volume 1, page number
46.
246.
Factually, I don't want to, my lord, I want to avoid the disputes. So these are the facts admitted by them. Two. We can give a separate page. Miller, page 246.
Yes.
Your lordship has got it. Page 246.
Yes, it is in the convenience volume.
No, my lord. The wrong page has been included.
Oh, wrong page has been included. Oh.
That is why.
ওটা 246 হবে, এই 246 টা দেখো।
That should be, my lord.
I see.
It should be 246, but page is wrong in the index as well as in the compilation.
So this 226 is not relevant.
No.
With 246. Replace the page.
Great. Why I say kindly come to page 246. It is their statement of defense.
Yes.
Paragraph 39. My lord, I am with reference to all statements, etc. I am, my lord, avoiding the denials. Kindly come, my lord, to the last line, last sentence, third line from the bottom of the page 246. It is stated that the claimant is only entitled to rupees 26590 62.00. Kindly come to the next page.
Yes.
Of the tender process, etc. So that is the, according to the respondent, the claimant has executed work for this amount.
Yes.
Not the amount which has been claimed in the statement of claim. In the statement of claim, statement of claim, in the statement of claim, your lordship kindly come, my lord, to the statement of claim, page 7, page 7, claim number 3 of the compilation. Paragraph 40, your lordship has seen at page 7 of the compilation.
Yes.
Third line, the total amount of work executed by the claimant is rupees 224, etc., out of the contractual amount of rupees 423, etc. So according to the claimant, it was much more. But according to the respondent, it is only 26 something. And if you kindly consider the next line of paragraph 40 at page 7 of compilation, in every contract, contractor's profit 15%, that is principal case. Then the difference they have calculated and 15% calculated is 2976, etc.
Yes.
What the learned arbitrator has done in calculation, right? Kindly come to item number 10 of the compilation, starting at page 15.
Yes.
I am trying to pinpoint this particular issue. Imposition of clause 2 and 3 contract. Then decisions have been, my lord, referred to. Kindly, my lord, ignore that for the moment. Then decision, page 17. Kindly come, my lord, to claim number 3 at page 18. Towards the bottom of that page, in the award, 84 Supreme Court, 1703, that principal has been informed, referred to. And then, accordingly, page 18 bottom.
Yes.
Accordingly, I hold that since the tender amount of the work is 423 something, and the value of the executed work of the claimant is 2659062. Kindly put a note, there should have been according to the respondent. That then it becomes admitted amount by the respondent. The claimant is entitled to 423, etc., minus 26, etc., and the 15% of this difference, which comes out to be 5951.
So you are saying the total value of the contract was 4.23 crore?
My lord.
According to this respondent, you did work worth 26.59 lakh.
My lord.
So 15% of the difference.
Yes. It's a calculation or finding of the learned arbitrator. Claimant said otherwise. Claimant said that I have done much more work.
Correct.
So the basis of the calculation is correct here.
So if you did much more work, this award balance would have come down.
Yes.
Yes.
Yes. Yes. Yes.
Exactly.
It's the difference that matters. And 15% of that.
Correct.
It is not, my lord, is as if, my lord, Section 34 code was of the opinion you have claimed only this much and you are getting so much amount. It is on admission regarding the quantum of work done or the amount of the work done.
If the calculation is made on the basis of the quantum of work done as per your client's case, how much would this 15%?
That is in the statement of claim. I just pointed out it. No. Kindly come to me, Lord. Claim number
40, page 40, page 7.
Yes. Page 7 of this compilation.
So it will be then, going by your statement, 15% of the difference between 4.23 crore and 2.24 crore, which will be much less. What are they saying? They must be saying it's a mistake, this and that.
No, what they are saying that it is in their favor. Award has been set aside. Award is set aside. Why I particularly point out to your lordship that it gives similar the impression that the claimant has claimed so little amount, 15%. Arbitrator has awarded such a big amount. Because the formula is 15% of the difference of the work which could not be.
Difference of the contract value and the value of the work done.
As simply put.
And according to them, the value of the work done is 26 lakh. Therefore,
it is not shocking. Why I point out now the trend is, it is so shocking that it will affect the conscience of the court.
He also said that in section 34, which is not an appeal, appreciation of facts and interpretation of clauses by the arbitrator should not be touched.
And that law point I shall come. I say that this is the main thing, conscience of the court. Now it has become a factor after in the judgments under the 96 Act.
Yes.
Because if your lordship considers claim number 3, why, my lord, I am on it particularly, kindly come to item number 6 of the compilation starting at page 7. I want to be more precise.
The learned trial court has come to the conclusion that the termination was not illegal. Termination of the contract was not illegal, not illegal.
Yes. So that comes in the entitlement part. Arbitrator has, my lord, I should say, constitute the clauses and the documents before him and has come to a particular conclusion.
Whether that finding could have been
Challenged.
Or touched by the
section 34. This is why today I try to pinpoint this issue, that this is the main shocking quote unquote aspect, which is really the matter of calculation and nothing more.
Yes.
And my lord, there are 3 notices. Kindly come to the index. First, item number 1 and 2 are 2 clauses. Then number 3, show cause notice, dated 17th April 2012. Then 4, imposition of penalty under clause 2, dated 1st June 2012. Then termination notice on 12 September 2012. These are the 3 documents. There is an observation in the impugned order that the arbitrator has not considered the notices, the documents before him. My lord, indicating that there is perversity. Now, I can point out, my lord, from the award, that there is reference to these 3 notices only. It is one stage I make submission that this is the notice that is such and such for show cause. This is the notice that is such and such for imposition of penalty. The notice that is such and such for termination. After that, it need not be referred to the dates also. Because everybody knows, if I say, for example, Aniruddha Mitra is my learned friend. It is nobody's case that there are 2 or 3 persons in this room with the same name. There should have been no confusion in the mind of the section 34 court. If the later on in the award portion or the reasoning portion, the arbitrator has not, learned arbitrator has not mentioned the date, that does not mean that he has not considered the letters or notices. Because there is an observation in the impugned order. So these are the 2 main factors I point out. And the other part, and the main thing is the interpretation of clauses 2 and 3. ওই পোর্শনটা বার করো কম্পাইলেশন থেকে, যেখানে না যেখানে বলেছে যে প্র্যাকটিক্যালি ক্লজ 2টা করেছে। কাইন্ডলি কাম মি লর্ড, আমার এখানে 34 অ্যাপ্লিকেশন। Kindly come, my lord. There are 2 orders, judgments, item number 11 and 12. Kindly have a look at to the index. I'm sorry.
এটা খুলে দাও।
If your lordship kindly look at,
Yes.
Item number 11 and 12.
Yes.
There are 2 judgments. First one was passed in section 34 petition filed by the state, kindly mark that. In the index it is indicated.
Yes.
And second one in the section 34 petition filed by the appellate.
Yes.
Now kindly come to page 20. এখানে পারবে কিছু বলতে পারবো না। So far as perversity aspect of in the order is concerned, kindly come straight away to page 33. Page 33. Internal page 14. Miller on conjoint perusal. Your lordship has found in the middle. In the middle of that page 33.
Yes.
Clause 2 and clause 3 of the agreement was discussed. Then on conjoint perusal of the reasoning as assigned by the arbitrator and clause 2 and 3 of the aforesaid agreement, it transpired to this court that the arbitrator, while allowing claim number 3 of the respondent firm, respondent means respondent in the section 34 application, came to a finding that the petitioners of the instant miss case wrongly invoked clause 2 of the agreement by using a so-called notice dated 17th April 2012, which according to clause 2 of the said agreement ought to have been issued by the superintending engineer only and by no others. Specific point taken.
Yes.
On perusal of the entire materials as placed before this court, it reveals that to this court that admittedly under cover of this letter dated 17th April 2012, the executive engineer PWD Tumluk issued a so-called notice to the respondent firm asking the said firm to assign reason as to why clause 2 of the agreement between them shall not be invoked. But issuing the said letter dated 17th April 2012, the executive engineer never invoked clause 2 of the agreement between the parties. On the basis of the materials placed before this court, it reveals to this court that subsequent to the issuance of the letter dated 17th April 2012 by the executive engineer, Tumluk Division, the superintending engineer PWD, such and such, by issuing this his letter dated 1st June 2012, kindly note the words used, practically invoke the clause 2 of the said agreement and thereby ask the respondent firm to pay the compensation to the tune of such and such. This practically invocation does not mean anything.
Yes,
Suppose I give a show cause notice. In the same show cause notice, I cannot impose penalty. Show cause notice must get the reply. If the superintending engineer is not satisfied, then penalty is imposed.
What the learned trial court has noted, rightly or wrongly, that we'll decide, that show cause was given by the executive engineer,
Right.
but penalty was imposed by the superintending engineer.
Yes, and our case was that penalty imposed on the basis of show cause notice, not issued by superintending engineer.
That is bad.
That is bad. That is precisely, maybe in Miller could have been in a better language, the first part of my submission today, page 33. Kindly come back.
Page 33.
Yes, just now I placed
Yes.
on conjoint perusal. And after 4th, 5th line, miscase wrongly, invoke the clause 2 of the agreement by issuing a so-called notice dated 17th April 2012, which according to clause 2 of the said agreement ought to have been issued by superintending engineer only and by no others. So that was the case made out by the claimant. The learned judge comes to the conclusion 17th April 2012 was issued by executive engineer. So what? The subsequent letter dated 1st June 2012, superintending engineer invoked clause 2 and thereby asked, then where is the show cause?
So whether or not the contractor is liable to pay compensation, and if so, in what amount, was for the superintending engineer to decide. He was the authority, not the executive engineer, and show cause also could not have been issued by the executive engineer, is your case.
Yes, because the authority or the person who will impose penalty,
who is empowered to impose penalty, the show cause must emanate from him.
I think I couldn't have put my words better than this. That is the crux of the matter here. And by logic, in the same notice, he practically invoke clause 2, practically no. Either you invoke clause 2, impose penalty, then where is the show cause notice? The imposition of penalty of under clause 2 cannot stand on the basis of a bad show cause notice issued by the executive engineer. Who didn't have the authority to impose penalty.
Yes.
Your Lordship will find, my lord, from the pleading or the submission recorded in the award, entire thing I am not referring because this is the crux of the matter. If the root is rotten, you don't get the fruit.
Clause 2 does not contemplate any role of the executive engineer.
Yes. I am grateful, man.
Prima facie, apparently, subject to hearing
Yes,
Mr. Chakraborty. Mr. Chakraborty is looking very grim because we are making these observations. Yes, we followed.
So may I, my lord, keeping this in view, may I invite your Lordship to go to the award, then come back to this. Kindly come, my lord, to page 15. Extract of the award, because only claim number 3 was allowed. Imposition of clause 2 and 3 of the contract. I am not reading out the entire thing, but the learned arbitrator has relied on AI 1936 Privy Council 253 for the proposition that where a power is given to do certain thing in a certain way, the thing must be done in that way or not at all. Then he has held
Yes.
The show cause notice under clause 2 of the contract was the jurisdiction of the superintending engineer. The same was issued by the executive engineer, which is contrary to the provision of clause 2 of the contract. So the show cause notice dated clause 2 is not legal and contractually wrong procedure. And since such notice is illegal and contractually wrong, imposition of clause 2 and subsequent imposition of clause 3 imposed by the executive engineer based on that illegal and contractually wrong show cause notice under clause 2 becomes void ab initio.
Mr. Ghosh, we have followed the factual aspect. We have followed it. Come to the authorities.
Authority. And, my lord, the only thing to point out from the award itself, claim 3, page 80.
Yes, we have marked it. Claim
The
3.
calculation part.
Yes.
This is entitlement part, and next one is the quantification part.
Termination is illegal. You have prevented the contractor from completing the job. The contractor could do job valued at rupees X. Contract value was rupees Y. So Y minus X, contractor could not do. You did not allow him to do 15% of this difference. Prithpal Singh. That is the story.
And the actual language used may be different in the award. So we can't expect, my lord, from an engineer to write, my lord, the prudent lawyer's language. But another thing, কোথায় বলেছে বলো যে এখানে consider করেন দেখি kindly come to page, sorry, I'm sorry. এটা কোথায় লেখা আছে? হ্যাঁ, আমাদের তো আছে আগে তো জানি।
Yes.
Another aspect, those small, page 34 of the convenience compilation.
Yes.
I was placing that, kindly come to the middle of the continuing paragraph. It appears to
Yes.
this court, your lordship has found it?
Yes.
It appears to this court that in his finding, the arbitrator has not mentioned anything about the letter dated 1st June 2012 as issued by the superintendent engineer PWD, etc. And this court has got no hesitation to hold that knowingly or unknowingly, the arbitrator overlooked the letter dated 1st June 2012 as written by the superintendent engineer to the respondent. That is the imposition of penalty. Notice, he has mentioned in that. I place this before your lordship, pages 15 and 16. In the reasoning portion, kindly come to page 16, to the middle of the continuing paragraph. So the show cause notice under clause 2 is not legal and contractually wrong procedure, and since notice is illegal and contractually wrong, imposition of clause 2 and subsequent imposition of clause 3 by the executive engineer based on illegal, etc. wrong.
No, clause 3 was not by the executive engineer.
Clause 3 was by executive engineer.
So clause 3 show cause? No. No.
My lord. Kindly come to me, lord, to the index.
No, what is clause 3?
Termination notice.
Clause 3 is termination.
Kindly come to Miller clause 2 first at page 1.
Clause 2 we have read.
Yeah. Clause 2, in the clause 2, I think it is for the superintending engineer. Superintending, kindly note. And clause 3, executive engineer, divisional officer. But
Is the executive engineer the divisional engineer?
yes, I'm told that.
So termination letter was issued by the proper authority.
The imposition was done by proper authority, superintending engineer.
Show cause was not
By superintending engineer, but by executive engineer. Now, if one...
Where is the reference to first learned judge said 1st June letter? The arbitrator has not referred to. Where is that reference?
Imposition.
1st June imposing the
date.
Imposing the penalty.
Penalty.
But learned judge has not addressed the issue, even assuming the penalty was imposed by the superintendent engineer.
Yes.
The show cause was not by him.
Yes. That's what I'm
That issue has
practically
not been.
invoked. He says practically invoked. You can't ask for the show cause in your show cause notice, and in the same notice you cannot impose penalty. Because it is as if you are setting down the question papers without getting the answer sheets. You are giving marks. That the student will get 0. That is the reasoning of the learned judge.
Show cause Yes.
Now, I don't think there should be any problem, my lord, regarding identification of the 3 notices.
One is show cause, one is imposition of penalty, one is termination.
That's all. There is no confusion in anyone's mind. I can go on narrating the entire award where both parties' submissions have been recorded. Pleadings, I can refer to the pleading. And since I take it, Miller, since these are part of the paper book, these were there. I can't, Miller, in section 37 application include something which was not before the learned arbitrator. In any event,
Yes, Mr. Ghosh, we have followed. We'll have to hear him also.
only the judgments.
Judgments.
Only the judgments. Kindly, my lord, I'm sorry to, my lord. Page 70 of the paper book 1. I did not include here. Kindly have a look at page 70, paragraph 21. There's a pleading of 1st June 2012 notice that has been annexed. No.
What is this? This is the
Statement of
statement of claim.
Because it has been the full name, if I may use the expression, of a person is given here. Name and surname. And there is no confusion regarding the identity of the letter or the notice.
Perhaps why the learned judge has made that observation, perhaps, is that your contention, the learned judge understood
My lord.
your contention as that executive engineer could not impose penalty. There, the learned judge is trying to say, as I understand, no, but the executive engineer did not impose penalty. Superintending engineer did. Arbitrator has not considered his letter dated 1st June. This must have been what was playing in his mind.
In such situation, Miller, when I face such a situation, I always submit before court that it was my fault that I could not convince the learned judge. The way I was making submission. But the record says, record is clear.
Yes, authorities.
No. Well, there are other portions. I think I should go. But the loss of profit has been considered to be interest, 15%. So in the award you
I've seen that. I was wondering, where does interest come in?
I am not making further comments on that. This is the logic that basis is the basis, the root is rotten, you cannot get the fruit. Now, okay, this is that AI 1936 Privy Council 253 second judgment. In those days, Miller, there used to be 2 judgments in the same page. In some of the
very concise,
very concise. One is 30 Privy Council, no amount of evidence can be looked into. There also you find 1 and 2. Now kindly come, Miller, this will.
Nobody these days cites Taylor versus Taylor anymore. That was the parent case.
It was yes. Yes, yes.
Is Nazir Ahmed considers Taylor versus Taylor?
Yes. These days we get a very few matters where we have to go, say, beyond 1900. Your Lordship kindly come straight away to page 257, right hand column. After the there is a line on the right hand side. After that, where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. Your Lordship has got it?
Page 257.
257, right hand column. There is a marking on the right hand side, a line. The sentence starting with, where a power is given to do a certain thing in a certain way.
Yes, yes, yes. Yes. Other methods are necessarily forbidden.
Now, next one I want to rely on. Yes. Now, 2015, Volume 3, Supreme Court Cases, page 49. Kindly note below the paragraph on which I want to rely. Paragraphs 1, 2, 14, 15, 17, 19, 42.3, 43, 44, 45, 59, 63.
59?
63. All the paragraphs, all the judgments quoted are important. I want to be as precise as possible. Paragraph 1 and 2 is only for Milord the context in which the judgment was passed. ওটা স্পেসিফিক্যালি পরে বলুন, ঠিক আছে, ওটা মনে করি। Then 14, 15, 17, your Lordship will find the provisions. Then 17. It will be seen that none of the grounds contained in subsection 2A of section 34 deal with the merit of the decision. That's what I'm on. Rendered by an arbitral award. It is only when we come to the award being in conflict with the public policy of India, the merits of the arbitral award are to be looked into under certain special circumstances. Then 19, paragraph 19, what is public policy? So nobody has submitted on behalf of the respondent or anybody that it is against the public policy. Then the judgments are there. Of course, I have missed one, paragraph 36. Kindly keep a note of it. Because the awarded amount is more than the amount claimed, 15%. Paragraph 36. The third ground of public policy is if an award is against justice or morality. These are two different concepts in law. An award can be said to be against justice only when it shocks the conscience of the court. An illustration of this can be given. A claimant is content with restricting his claim, let us say rupees 30 lakhs, in a statement of claim.
Without any acceptable reason.
Right. Before the arbitrator, and at no point of time does he seek to claim anything more. The arbitral award, etc., 45 lakhs without any acceptable reason. Because once the work done amount is less, the difference will be more. There is no doubt about it. That is why I said this is the exception to this particular paragraph 33, that when court can go into this particular aspect. Amount awarded is more than the amount claimed. Then 42.3. 42, patent illegality starts. Para 42.
Yes.
After quoting 28, this last contravention in 42.3 must be understood with a caveat. An arbitral tribunal must decide in accordance with the terms of the contract. But if an arbitrator construes the term of the contract in a reasonable manner, it will not mean that the award can be set aside on this ground. Construction of the terms of a contract is primarily for an arbitrator to decide unless the arbitrator construes the contract in such a way that it could be said to be something that no fair-minded or reasonable person could do. Then, my lord,
43.
43, 44, 45. Just reference to McDermott, 43, and the principle laid down therein. 44 is MSK, State of Rajasthan. 45 is, all says the same thing. Kindly come to paragraph 45. I am not separately showing these judgments. I am relying on this portion. Wherein, my lord, for para 43 of Rashtriya Ispat has been quoted. In any case, assuming that clause 9.3 was capable of two interpretations, the view taken by the arbitrator was clearly a possible, if not a plausible one. If it is not possible to say that the arbitrator had traveled outside his jurisdiction, or that the view taken by him was against the terms of the contract, that being the position, the High Court had no reason to interfere with the award and substitute its view in place of the interpretation accepted by the arbitrator. That is the law. It is not a court of appeal. Section 34 court. Then also therein, Miller, other earlier judgments have been quoted in that paragraph 45. He says the same thing in different ways. Then kindly come to paragraph 59, I believe. The arbitrator has dealt with this clause in detail and has construed and applied the same correctly while dealing with claims such and such, and has obviously not applied the said clause to claims such and such, as no occasion of applying the same error. The award cannot be faulted on this ground. So only ambiguity was the document was not considered in the reasoning of the learned first court. And my lord, ultimately, my lord, 62, 63. দেখো মোটা 2024, দাও Hindustan Construction, 2024 2 SCC 613, next judgment. When there are very many judgments, I consciously avoid the same.
Please. এটা ছিঁড়ে গেছে স্টেপল করে দিয়ে দাও দেখতে
I guess the winner. Miller, kindly note paragraphs 26, 27, 28 and 33. যত বলবি তত বেশি হয়ে যাবে আমি ভুলে গেলাম কত 26. Kindly come, Milord. Again, Milord, I am avoiding the history and the trajectory of judgments. (26) The prevailing view about the standard of scrutiny, not judicial review of an award, by persons of the disputant's choice being that of their decisions to stand. This is very important, but parties have chosen and not interfered with, save a small area where it is established that such a view is premised on a patent illegality or interpretation of fact or terms perverse as to qualify for interference. Court have to necessarily choose the path of least interference except when absolutely necessary. By training, inclination, and experience, judges tend to adopt a corrective length, usually commended for appellate review. However, that length is unavailable when exercising jurisdiction under Section 34 of the Act. Court cannot, through process of primary contract interpretation, thus create pathways to the kind of review which is forbidden under Section 34. So viewed, the division bench approach of appellate review twice removed, so to say, under Section 37, and conclusion drawn by it resulted in displacing the majority view of the tribunal in that case. And in many cases, the unanimous view of the other tribunal and substitution of another view, as long as the view adopted by the majority was plausible, and this court finds no reason to hold otherwise, because consequently the work was completed and finished embankment was made composite, etc., etc., in facts of that case. Then, my lord, 27, 28, 33. This is also relied on some earlier judgment. Paragraph 4 has been quoted. In that quotation, your lordship find in the middle, I am not reading it out, Sudarshan trading is mentioned, which is under 1940 Act.
Yes.
So that principle has been, my lord, applied here. Then 28. My lord, paragraph 42 of that 42.3. I pointed out to your lordship, the same thing has been written here. If an arbitrator construes a term of the contract in a reasonable manner, it will not mean that the award can be set aside on this ground. Construction of the terms of a contract is primarily for an arbitrator to decide, unless the arbitrator construes the contract in such a way that it could be said to be something that no fair-minded or reasonable person could do. And the result is, of course, Miller. 33. ওটা দিয়ে দাও দেখি it is so well known Miller principle Beachpal no. We are giving the SCC version 1984 4 Supreme Court cases page 39 80 Beachpal which is equivalent to judgment at the actual okay now AIR 1984 Supreme Court page is written there, the same judgment. Lord, paragraph 11 kindly note. Your Lordship must have considered Miller this earlier, so I am not placing the entire thing. The principal letter. Now, paragraph 11, now if it is well established that the respondent was guilty of breach of contract, inasmuch as the remission of contract by the respondent is held to be unjustified, the plaintiff contractor has executed a part of the works contract. The contractor would be entitled to damages by way of loss of profit. Adopting the measure accepted by the High Court in the facts of the circumstances of the case between the same parties and for the same time of work at 15% of the value of the remaining part of the contract, the damages for loss of profit can be measured. So 15% important what? 15% of the value of the remaining parts of the works contract. I think after and those are my
Papers it has gone by mistake.
কত নম্বর পেজটা বলো ওখানে?
226.
Yes.
You can replace it.
You replace it, but don't touch the other pages. We have marked it.
No, এটা স্টেপল করে দিন।
হ্যাঁ, এটা শোনো, ওই যেটা দিচ্ছেন এখানে এটা ভুল আছে।
I think
সিরিয়াল নাম্বার 9 যেটা পেজ 14।
14A.
Page 14 can be taken out.
Yes.
Replaced by
14A.
Huh? There are 2 pages here. Continuation.
I see.
One paragraph is a
ওই করে ওটা ঢুকিয়ে 14 আর 14A করে দাও, আমরা ঘুরে আসছি। We'll be back in 3-4 minutes. ডাকো কোথায়?
It has been done.
Yes, Mr. Chakraborty.
Yes. Well, what is there in admission in pleadings, I cannot improve on those things. But my lord, my contention would be, my learned senior friend the first day had said, the interpretation of contracts is an error which is within the jurisdiction of the arbitrator.
Supreme Court appears to be saying so also.
Supreme Court says, but my lord, I'll try to show when I'm saying interpretation of a contract, it means that there has to be something in the clause to interpret, or there has to be some ambiguity in the clause to interpret a clause that the contract. My clause 2, with deepest respect, my learned senior friend has also accepted the situation. There was no requirement of issuance of show cause.
No, I said there is no mention.
There
I
is no
never said-
mention.
No requirement.
I'll correct it, my lord. So, my lord, today, whether the arbitrator can import a particular clause to it and decides that which authority should issue that notice. If the clause 2, my lord, subject to correction, my lord, has read this, just for my satisfaction, my lord, would kindly see page 31 of the compilation. I'm also, because my lord, it is more on a front is bigger, so I'm relying on this clause 2, page 31 of that compilation. Kindly see, it's part of the order passed by the learned court below. My lord has seen clause 2.
Yes.
Yes, just for my satisfaction, I'm just revisiting that issue.
Yes.
Right. The time allowed for carrying out the work as entered in the tender shall be strictly observed by the contractor and shall be reckoned from the date on which the order to commence work is given to the contractor. The work shall be proceeded throughout the stipulated period of the contract with all due diligence, and the contractor shall pay as compensation an amount equal to 1% or such smaller amount as the superintendent engineer whose decision may decide on the amount of the whole works shown in the tender for everyday delay and the days for which the work remains uncommenced or unfinished after the proper completion date. The contractor shall commence execution of such part of the work as may be so and so. Just the last 5 lines, in the event of the contractor failing to comply with any of the conditions, he shall be liable to pay compensation an amount equal to 1% or such smaller amount as the superintendent engineer whose decision in writing shall be final may decide on the tendered contract. This contemplation of issuance of a show cause notice is not part of clause 2. And he adds another, he imports another clause to it, that this has to be issued by the superintendent engineer. These are not there, my lord. My lord, when a clause, there is no requirement to constitute it differently. My lord, as a settled proposition, the plain reading has to be, plain meaning has to be given to it. My lord, I just want to rely on a division bench judgment. Well, this is 2024 SCC Online Delhi 3065. My lord, here the railway had challenged the Union of India. My lord, paragraph 2, my lord, would find the Union of India had challenged the award under section 34, which was accepted, my lord, and thereafter, my lord, 37 was preferred by the contractor. My lord, one of the points that was raised here, that this is the construction of a contract is to be by the arbitrator, my lord would find that the argument of the petitioner in that matter starts from paragraph 11, submission of the counsels. And this, my lord, 11.1, kindly see, the interpretation of contracts falls within the domain of the arbitral tribunal. Now, this was the submission. The learned tribunal arbitrator had furnished reasons why so-and-so was entitled to a higher rate per wagon. In this context, the learned arbitrator had noticed that so-and-so was subjected to economic duress, unfairness, and malafide exercise of powers invested in Union of India under the option clause. The learned single judge has lost sight of this aspect of the matter. Now, again, my lord, 11.7. It is a well established that if an arbitrator commits an error in the construction of the contract, it is an error that falls within the jurisdiction. Now, this was the submission. Now, considering this aspects, considering paragraph 17, what was the answer? It is a treat law that an implied term is read into the contract to give it business efficacy only if it does not collide with the express terms of the contract. That said, before an implied term can be read into a contract, in addition, the following conditions must also be met. The implied term should be reasonable, equitable, and something the parties always intended to agree to. In the instant case, and thereafter there's a reference to a Supreme Court. In the instant case, since Union of India expressly reserves the right in the subject contract to increase or decrease the ordered quantities to protect its commercial interests, goes against JRL's submissions that the 2016 tender rates should apply to the additional quantities. Any other approach would neither be reasonable nor equitable. In fact, it would lead to loss to public revenue. The submissions advanced on behalf of JRL that the interpretation of a contract falls within the domain of the arbitrator is a submission with which one cannot quibble. That said, the rule of interpretation kick in only when a contract or particular clause is vague or ambiguous. The purpose of employing interpretation tool is to ascertain parties' intent when they first enter into the contract. The best tool to determine the party's intent is the plain word of the contract. In the given case, the words of a particular clause. If the words of a contract or a clause incorporated in the contract are clear, explicit, and unambiguous, ordinarily they have to be given their full effect. The intention of the parties is to be ascertained in the first instance from the meaning of the words they have used. Intention independent of that meaning is often cause of confusion while the process of construction is on. It is good to remember that the parties who are knowledgeable and experienced and can also have the benefit of legal advice are taken to have intended what is stated in the contract. Therefore, argument that the interpretation of clause falls within the domain of an arbitrator is a submission which, in our opinion, is untenable, and there was without doubt no scope for employing interpretation tool. And here, the learned arbitrator puts in a new clause which is not there. Well, it is also, I'll show my Supreme Court judgment. It is also a fact that arbitrator, while deciding, has to be in terms of the agreement, not beyond the agreement.
Section 28.3.
28.3.
Yes.
That is what I am harping. My point of contention is, when the learned court below had said he does not decide on the issue of the imposition of the penalty, which was done by the correct authority, it means, my lord, he fails to take into consideration the terms of the contract. My lord, the question of interpretation of contract would only come when there is some confusion or there is a vagueness Here, the imposition is by the authority which is contemplated under the contract. My lord would kindly see from the compilation how the arbitrator has proceeded on this issue was page 15. Just for record's sake, the observation of the arbitrator starts from page 477. Although 1st June was argued, admitted position that this was part of the record, but my lord would not find a mention of it any. There are other correspondence. There are correspondence from superintendent engineer saying there is a delay in the work, and there are at least umpteen number of letters from both executive engineer and superintendent engineer saying there's a delay in work. So the clause 2 is saying that there should not be a delay. So there was warning much before that also. But there are correspondence just because the factual possibly my lord cannot go into that factual aspects. That's why although if my lord wants, I can show those documents, all this correspondence. My lord, kindly see 6, imposition of clause 2 and 3 of the contract page.
Yes.
As per clause 2 of the contract, superintendent is authorized to issue clause 2 of the contract. My lord, he does not answer this with my deepest respect. My lord, the first line, he says the superintendent has to issue clause 2, my lord, which has been done in the present case. Thereafter says, here the executive engineer has issued show cause notice to the client. But these two are subject to correction. But these two are possibly contradictory. Now kindly see, but with deepest respect, Privy Council's judgment, brilliant proposition of law, possibly an interpretation of a contract, but it does not. It possibly supports me if it has to be done in some way. If the power is given to do it a certain way, it has to be done in certain way. The arbitrator comes with the conclusion that there is in the contract itself, there's a clause for issuance of show cause. But that's why he says, now kindly see the next page. Considering this statute, the fifth line, my lord, which statute I do not know, upheld by the Honorable Supreme Court. Then also it can be inferred though imposition of show cause notice under clause 2 of the contract was the jurisdiction of the superintendent of engineer. This does not comes within any of the contractual obligations. So, the interpretation of clause contract cannot import a clause which is not part of the entire contract. I could have understood this was part of somewhere there is written. He imports a clause, a condition which is to be fulfilled, and he says that is not being fulfilled, everything goes bad. But I say that precondition was never part of the contractual obligations. And the first line he said, superintendent engineer has to impose clause 2. Thereafter, he does not deal with what is the effect of the 1st June letter, which is being considered at the time of by the learned court below. At the time of passing on, what would be the consequence if an authority, I can understand the show cause notice issued by one authority, the actual imposition is by the authority which is contemplated under the contract. Then what happens? He does not discuss this issue at all. He doesn't discuss this issue. He on his own, he includes a term which is not part of the contract and considers this. Just another Supreme Court judgment we can just rely on. I should do. আমি কোনটা দিলাম না আপনাদের But I have handed over 2022 volume 2. Sir, আমি পরে দিচ্ছি আমার একটাই সরি মানে 2022 to SCC 275. It's a 3 judges bench. Sorry. Well, kindly see, I do not want to. Paragraph 23 I'm relying on. 23 and 26. On a conspectus of facts of the case, it remains undisputed that though the appellate state did raise an objection before the arbitral tribunal on the claim of the respondent company seeking deduction of supervision charges for which it relied on clause so and so of the agreement and circular to assert that recovery of supervision charges along with expenses was a part and parcel of the contract executed with the respondent company. The objection was turned down by the learned sole arbitrator by giving a completely go by to the terms and conditions of the agreement governing the parties, and observing that there is no basis to admit such indirect expenses. Thereafter, kindly see paragraph 26. To sum up, existence of clause 6b in the agreement governing the parties has not been disputed, nor has the application of the circular dated so and so issued by the government of Madhya Pradesh regarding imposition of 10% supervision charges and adding the same to cost of the SAL seats after deducting the actual expenditure being questioned by the respondent company. We are therefore, in view that a failure on the part of the learned sole arbitrator to decide in accordance with the terms of the contract governing the parties would certainly attract the patent illegality ground as the said arbitral tribunal, as the said oversight amounts to gross contravention of section 28(3) of the 1996 Act that enjoins. The said patent illegality is not only apparent on the face of the award, it goes to the very root of the matter and deserves interference. But this is what I'm saying. But it has to be within the four corners of the contract. Interpretation and a plausible interpretation cannot mean he can import a new clause, which is not there. Now, my lord, the order passed.
Yes. Already.
My lord, obviously, my lord, today there has been an explanation, but one of the argument was at page 24 on our behalf. in courts of the learned advocate for the petitioner at the very outset draws attention of this court to the arbitral award dated so and so. It is contended on behalf of the petitioners, means the government of West Bengal, because this was a section 34 of the that the arbitrator, while passing the award, committed patent illegality, since the arbitrator awarded rupees so and so in favor of the respondent of the instant miscellaneous case towards their cost of profit, though in the statement of claim before the arbitrator, the respondent claimant firm claimed rupees so. It is argued that an arbitrator has got no power or authority to increase the claim amount of the claimant suo motu. And this was one of the submissions. Now, my lord, when the learned court below my lord would kindly see page 34. Page 34, tender apology, page 34. In order to decide, the second paragraph, my lord, as to whether the omission on the part of the arbitrator attracts the provisions of section 34(2) or 2A of the said act, the court proposes to look into the reported decision of Sangyong Engineering and Construction Company. What is important to note, that decision, which is perverse as understood in paragraph 31 and 32 of Associated Builders, while no longer being a ground for challenge under the public policy of India, would certainly amount to a patent illegality on the face of the award. That's a finding based on no evidence at all, or an award which ignores vital evidence in arriving at its decision would be perverse and liable to be set aside on the ground of patent illegality. Now, this was the considered. He has imported a new clause and failed to consider the 1st June, the imposition of penalty, the correspondence where the imposition of penalty was done. But that is a vital, that is, I would say, the vital evidence which the learned arbitrator failed to consider. Well, this is my submission, my learner. And my lord, there is no dispute about the proposition of the judgment, but in my case, again I repeat, my lord, just for say, the question is, my lord, my learned senior friend has said that there is an interpretation is within the jurisdiction of contract, is within the jurisdiction of the arbitrator. But I say interpretation does not mean you can import some new clause to it. And there was no occasion to interpret, as the Delhi High Court says, because the plain reading was very clear that the imposition can be given by the superintendent, which has been done in the present case. If my imposition is correct, my termination remains, because the arbitrator has gone on the basis that the show cause, which is not show cause under clause 2, which is not part of any contractual obligations, was incorrect. So everything flows from there. So everything is perverse. So there was no independent finding as regard to the 1st June letter or the termination notice. And this is my submission.
Anticipate.
I'll tell you. Mr. Chakraborty says that there is no requirement of a show cause notice. Now, you can legitimately say that since penalty would entail civil consequences, natural justice will have to be read into the clause, and therefore show cause notice will have to be read into. And the show cause notice was to be issued by the superintending engineer. This may be your answer. I don't know.
And that is not the case made out by them. I can, anticipating this, I have included the pages of the pleadings. They are just pointing out Milord the pages
In the compilation.
in the compilation.
Yes.
Kindly, I'm sorry. Kindly come, Milord, to serial number 7, readings in SOC, statement of claim about illegal issuance of so-called notice. Pages, Milord, 10 and 11. Kindly come to page 10. Paragraph 18. Respondent number 3. Respondent number 3. Milord, in the arbitration, the executive engineer was respondent number 3.
Yes.
He issued the so-called notice. And kindly come, Milord, to the date of the letter, 17th April 2022. The letter is, Milord, identified and annexed at page 11. And then paragraph 19. The claimant states that the said purported action of the respondent number 3 is illegal, etc., etc. I have already placed below the submissions made. This is the case made out in the statement of claim. Now, kindly take page 12. Well, kindly come to page 10 for your lordship's convenience. Kindly take a SOC at the top. Otherwise, there may be confusion later. Page 10 and 11, pages 10 and 11 are SOC.
Yes.
Kindly keep a note, otherwise, there is no indication in the page.
In the index, it is stated.
In the index, it is stated. Page 12 and 13 are the corresponding paragraphs of SOD. Paragraph 24 of Statement of Defense at page 12 deals with paragraph 17 and 18, that clause 2 notice. Kindly come a few lines in paragraph from the sentence. It is also denied that the respondent did not perform its obligation and instead purportedly, wrongfully motivated, issued so-called notice. There is no whisper that the so-called notice was not required. No, that's it. This dispute was submitted to the learned arbitrator. And now kindly come to, sorry.
Yes.
Kindly come to the next page, continuation of same paragraph, 24. Second line, it is also stated that again with a letter number such and such dated 17th April 2012, the respondent number 3 had stated the main reason of serving the show cause to the claimant. There is no whisper that there was no provision for issuing show cause notice. Then paragraph 25. Miller, fourth line, it is dealing with para 19 of SOC. It is also denied that the action of the respondent number 3 is illegal, contractually wrong, malafide, manifestly bad, etc. So I need not trouble your lordship. This is a dispute which was referred to, or the controversial point which was referred to the learned arbitrator for adjudication.
Please point out, issues were framed must be by the arbitrator. In the award, just Mr. Mitru, go through the award once. Hey, now to volume 1 ta kothai ekhane. Where is the award in the paper book?
15. 415.
কোন পেজটা এখানে আছে বলো?
415.
It starts from 415.
503 index says.
Twice, my lord. It is
Twice.
এটা পেজের
415 টা দাও, volume টা.
Page number.
No, it doesn't appear that any issue was framed formally.
not specifically. But there, your lordship note the judgment decision. Kindly come, Miller, to page 21 of the compilation. The judgment. What was the case made out by the state? Page 21, Miller, last paragraph, it is the case of the petitioners, that means the state of West Bengal. That has been, Miller, set out here. Kindly come, Miller, to the last portion, third line from the bottom. It is a further case of the petitioners of the instant successor that in spite of receipt of the said letter and subsequent reminder letter, the respondent failed and neglected to complete the work under the reference within the stipulated time, and thus the executive engineer PWD Tomnuk Division, under cover of his letter dated 17th April 2012, issued a show-cause notice upon the respondent of the instant successor, asking the said firm to show cause as to why an action under clause 2 of the agreement would not be taken against the said firm on account of delay. So the fact that that particular notice issued by the executive engineer was a notice to show cause why there won't be any imposition of penalty, that clinches the issue.
Only one thing is troubling me, Mr. Ghosh. Assuming that the finding of the arbitrator regarding illegal termination of contract is upheld, what is troubling me is the quantum. You claimed 29 lakhs in the statement of claim. Now, in its wisdom, the state in its defense said that you completed work valued at rupees 26 lakhs, when it should have been, as per your case, more than 2 crore. Can you take advantage of, when you have run a case, the state has run a case which actually, why not, which is to your advantage against their own interest? The claimant, I suppose, can take advantage of that.
Judgment upon admission, just like that. Award on admission. I say I have done 1 lakh job. They said
Firm Srinivas, 51 Supreme Court, Firm Srinivas, I think, that a decree can be passed entirely on the basis of concession or admission of the.
I think there is no problem with regard to that paragraph 33 or 34. I pointed out associated. Kindly have a look at that.
Without any reason or justification.
Because here the scope of inquiry under 37 or 34 even is very little. It is not perverse, it is on their admission. The universe party.
Firm Srinivas Ramkumar versus Mohabi Prasad, 1951 Supreme Court. I may be wrong,
Yes.
but just check up once.
Yes.
You have all those gadgets with you, Mr. Mitro. It appears to be saying it is established that courts can grant relief that is inconsistent with the plaintiff's original pleadings if the defendant's own admissions provide grounds for an alternative claim and no injustice would be caused.
Only thing, Lord, this is in our favor, but I don't want to directly apply this because the scope of inquiry in Arbitration 34, Arbitration Act 34, is something I say not as wide as that of a court under CPC. There I am a bit hesitant.
Right.
Principle, I accept that's the correct principle. But to make submission on that,
you have claimed rupees X. The state has run a case which actually entitles you to X plus Y.
X plus Y.
Did the arbitrator commit an error in awarding you X plus Y?
On the basis of the admission made by.
That is all?
That is all. Only thing, Miller, the judgment cited, I think kindly have a look at those judgments. First one is 2024 SCC, Delhi, SCC Online Delhi. My learned friend has relied on paragraph 17.
AI 51 Supreme Court. AI 51 Supreme Court.
177.
177. You know who taught me this judgment? Late Pranab Roy.
I wish I had his notebook.
Yes. You know, some judgments, they just get embedded in your head. This is one of them.
And I don't know what will be his, what could have been his attitude toward these things. And I also use. He told me that I had a habit of flagging at that point of time the pages. He told me about in a conference, I think Mr. Bulu Ghosh, his statement that he took away all the slips or the sticker, not the sticker, the slips. In his time that there were slips to be attached. Keep it in your mind.
How many judges?
3 judges.
3 judges.
All CJ. Patanjali Shastri, MC Mahajan, BK Mukherjee. All CJ.
Principle, I agree. But the problem is that I must point out what is in my mind. Section 19, I believe, of the Arbitration Act. Okay. Is not bound by. Is not bound by.
Yes, shall not be bound.
It is not that it is not applicable.
Correct.
I don't want any
Not necessary.
controversy because I had the trouble of arguing on this. Suppose if he says, just like evidence, just for Milord discussion's sake, Evidence Act says in section 1 that it is not 1872 Act says that it is not applicable to arbitration. That was the final thing. 1940 Act, there are some judgments that principles will apply. But in section 19, it says the principle is not bound by such and such.
Not bound.
Not bound means that rigor is a bit made a bit fluid.
Not bound means that the arbitral tribunal will be free to decide on the procedure.
That's all.
Yes.
That's all. Nothing more than that.
Yes.
So I don't want to go into that controversy. I say that from the records on the disclose or the statement made by the respondent state, it is evident that it has come down, so the difference will be more. We calculate 15% on that. And this judgment of Delhi High Court, it says that it's just like this. Both parties made out their cases. Can the court make out a third case? Again, Miller, I don't want to go into that line of decisions. You can't.
Yes.
Paragraph 17 of the judgment, Delhi High Court judgment, is not applicable because here this is the dispute with which I went to the learned arbitral tribunal. They made out a case in defense. That was the case made out by the respondent state in their application under section 34 as recorded in the judgment under appeal. The show cause notice is the show cause notice for imposition of penalty. That ends the matter. And 22 2 SCC, paragraph 23 and 26, particularly 26, again at the risk of repetition, I submit, that if the parties themselves go to the arbitrator with a particular dispute, and arbitrator has decided that. Now the question will be whether that, question was not whether the show cause notice issued by the executive engineer was for imposition of penalty. In legal language, this should have been an issue. But that is not the case made out. In the judgment, the submission record says otherwise.
Very well, Mr. It, we are not reserving judgment. We will possibly dictate the judgment in court. We are listing it as for orders on appellate side, appellate side. আজকে হচ্ছে 12 23rd of 24th of June.
24th of June.
24th.
Only thing we got the second appeal in the
yes.
In the list. I have made my submission, you lordship will take. Because kindly do not because I have faced this institution.
One was rejected of 2 crores for the execution of the work. No, for execution of the work.
The judgment in the second setting
Yes,
aside,
that is
you are
there.
setting aside, is there.
On 38, page 38.
All right then. একসঙ্গে হচ্ছে দুটো appeal. Hearing is concluded. Stop. List the matters as under the heading for orders on June 24. আজকেই পাঠিয়ে দেবে আমাকে এইটাকে স্টেপল করো করে ফাইলে ভরে
এটা পাঠিয়ে
Item 7,
My lord, I appear for
Yes.
my lord, I appear for the appellant, my lord. My lord, I am being led by Mr. Amit Kumar Nag. I am praying for a not today. Or my lord, Mr. Chatterjee can make his submission. I will give a reply on the next day. my lord.
No. This piecemeal thing we detest. You have made your opening submission already.
Right.
এই কিছু নোট আছে নাকি?
No.
What is the issue?
The point was whether, my lord, the arbitrator who's been ineligible to be appointed as an arbitrator, my lord, whether even after giving the award, passing the award, my lord, whether we can challenge it or not.
Oh, I see.
Point.
Yes.
So that was the point, apart from the other points, my lord, which were there. My lord, he's ineligible to be appointed. He was the director automation, my lord, ED automation of Indian Oil Corporation. He made a public, then an application had been made, my lord, for the arbitrator to take fees and
Yes, remember. Then come back when? Not today, you said.
I'm not.
Not today really means Tuesday. Appellate side.
My
Come
lord, I
back
will
on.
request Mr. Chatterjee to share with
Yes, if you are relying on authorities, and we are sure you will, give them the citations so that they can come prepared to distinguish. Otherwise, they'll again say, give us time, we'll consider. It creates difficulty for us, Mr. Chatterjee.
Tuesday, my lord, effectively takes us to 17 June.
Today is 12th.
12th.
Yes, 17th. Is that all right?
Or maybe, my lord, subject to my lord's convenience some other day, my lord.
19th?
19th.
Next Thursday? Accommodation lekho. Accommodation is prayed for on behalf of the appellant. Stop. As requested, comma, let this matter be listed again on June 19. Give them the citations.
Right away. My lord,
There is a very recent decision of the Supreme Court, my sister points out, I have not read it, which appears to be saying that this objection, this waiver has to be by an
express agreement in writing.
agreement in
My lord,
writing.
I've brought, my lord, BSNL, my lord, United
You
Telecoms.
give the citations to them.
Yes, my lord. My lord.
Okay. Give the citations to them. Consider, come back. They want time, Mr. Banerjee. We don't want this to be had piecemeal.
No.
Next Thursday, you will complete, they will complete. We'll see what we do.
This was the initial point which was raised, my lord, because there are
The initial point is enough, my lord. I am satisfied. I can satisfy my lord also. Its initial point is now, my lord,
BSNL.
decided.
BSNL.
BSNL, my lord, and there's a Bombay High Court judgment. I think, my lord, with all due respect, very well written, my lord. Considering BSNL even very well written, considering all the Supreme Court judgments.
Yes, for it.
Share the citations.
Because sharing will not change the rule.
Correct.
Share it with him so that
To
he
save
also-
time.
Absolutely, my lord. Absolutely, my lord. Absolutely. I'll give it to
We have posted it next Thursday.
Great.
But in fact, Elora is also there.
Retaining its position. Retaining its position.
He has considered all of them. I think, my lord, better than BSNL, my lord, I will give a copy to my lord's officer also. The Bombay High Court judgment is very well written. Very well written.
Not by somebody from this court, no.
No. But my lord, there are a lot of judgments of this court also. And my lord, Supreme Court judgments have been dealt with in such a nice manner that it shows a different light altogether. Especially when it was dealt, my lord, in this mobile.
Right then, Thursday.
Grateful. Great.
I'm so grateful, my lord.
Item 8.
My lord, I am appearing behalf of the petitioner. My lord, service is not effected. Kindly make the matter after 2 weeks. Service is not effected. My
Who are you appealing for?
Lord, I am appearing for the appellate, Lord. But against that order, they have preferred this review application, Lord. I have my learned friend has said that the copy of the review application has not been served. Yes, that is correct, Lord. So let them.
Why
serve the
2
copy.
weeks? He's appearing, sir. Give him a copy. Everybody is appearing. Give them copies. Why do you want 2 weeks? Come back next.
There was a direction passed by your lordship for remanding that matter before the land deed court.
Against that review.
Against that, they have preferred this review. And there was a direction for filing a affidavit on opposition and reply. So we have already prepared.
Are you in a position to do the matter? Forget about service.
lord, kindly not to do, my lord.
Say that.
If they are willing, let that be adjourned. In the meantime, let them serve
Not
the copy
today.
to us.
Serve copies. There's nothing. Remand. What review asking for?
There's a
এই পাঁচা মামলাগুলো পেন্ডিং থেকে যায় না নেক্সট দিন করে দেবো give them copies today itself.
careful to rush.
Item 9.
আচ্ছা
9 ছিল না ইউজুয়াল অর্ডার অপূর্ব
Usual order মানে dismiss. This one default. আচ্ছা এরপর হবে তোমার 10 11
ছিল না ইউজুয়াল অর্ডার
Okay. 13 and 14. 13 with 14.
Same.
My lord, 13 contempt.
Contempt 13 yes.
My lord, I am led by Mr. Owen Banerjee lordship.
For the petitioner.
For the petitioner, my lord. Contempt.
Oh yes, Mr. Joyanto Mitro.
I have a telephonic conversation with Mr. Sundipon Banerjee, my lord. He said that Mr. Mitra has not come to the court today.
Yes.
And earlier order, my lord lordships directed them to file their report. They have filed their report. They have served us. Our exception, my lord, we have filed our exception, but service is not affected.
So tell us, you want it when next week?
Next week, lordship.
Next Tuesday?
Next Tuesday, lordship.
The respondents are not represented. Stop. On the request of learned advocate for the petitioner, comma, let this matter be listed again on Mongolwar date the 17 June.
17th, lordship. In the meantime, I'll serve the report. 13 only 13. Lordship, much obliged.
Item 15.
15 you are appearing?
The learned advocate Sambuddha Datta is on his way. So if you could.
Appearing for whom?
My lord, the alleged head contempt.
Contempt, petitioner কেউ নেই, first call-এও ছিল না, বুঝেছো? Usual order. Give his appearance.
Item 16. Seventeen.
Same, same. Commercial দেখো।
One. Commercial matter, item number 1.
I'm for the appellant plaintiff, my lord. As per my lord's last direction, I have served, my lord. There, my lord.
Extremely sorry, my lord. On the last occasion, my lord, I was not here.
You were not there. We don't even remember.
My lord, the lordship's direction that will have notice upon us so that we can be present.
Oh, yes.
My lord kindly takes up can 4.
Can for a copy?
What is can 4?
Can 4 relates to amendment of plaint, application seeking for amendment of plaint. By praying to incorporate state of West Bengal as party.
Can 4, I have not received the.
Well, I have served, my lord. Earlier, I have served.
So why amendment of plaint before us? Why not before the learned trial court?
My lord, the amendment is such of nature, my lord, that it will not change the nature and character of
That's
the
not
suit,
the
my lord.
question. The suit is pending.
Suit is disposed of. First appeal. This is regular first appeal, my lord.
I see. Suit is disposed of.
Disposed of, my lord.
Stand is non-compliance of 79. So,
My lord, whereas
For the state.
my lord,
my lord, I have annexed the written statement with the amendment application, my lord, wherein the executive engineer has filed his written statement by saying that he has been duly authorized by the state of West Bengal to file the written statement, whereas he was the state of West Bengal was not party. One thing, my lord, and other point is, my lord, no evidence has been produced by them stating that such and such documents are in possession with the state of West Bengal. My lord, all the evidences were all on record, my lord.
You have not followed, still not followed anything. You filed a suit for what?
May I state, my lord?
You filed a suit for what?
Suit for recovery of money to the tune of 79 lakhs, my lord. What has happened, my lord? The contract which I was awarded, my lord, that was pre-GST contract. During the interregnum period, my lord, the GST Act came into effect, my lord. During the time of execution of the project, my lord, I had to purchase things by paying GST. For which I have to incur extra amount, my lord. That amounted to 70 lakhs and odd, my lord.
For recovery of that, you have filed the suit.
Yes, my lord.
Your suit has been dismissed.
Dismissed. On my lord, 3 scores. First score, my lord,
So who was the defendant in the suit?
defendant was the executive engineer, my
Sole
lord.
defendant.
Sole defendant, my lord.
Now, why do you want to bring in the state?
My lord,
Executive engineer is the state's officer.
yes, my lord. My lord, one of the ground for dismissal of the suit was, my lord, the state has not been made party. And other ground, there are 3 grounds of rejection of plaint. First is, my lord.
Anyway, if we add the state, you will only represent the state. So let that be allowed. He can for
our contention was that non-compliance of 79.
We'll consider the merits. We'll consider the merits.
Only, my lord, they ask them to serve a copy of.
I have served, my lord. I've served. I've served, my lord.
Acha, give another copy.
Only one copy, সবাইকে দিয়েছি।
We don't dismiss, right? The technical.
আমি একটা কপি দিয়ে দিচ্ছি।
I have received.
So was the suit dismissed only on the ground that state is not a party?
No,
Please
please court, my lord.
On merit
One of the ground was that state of West Bengal was not a party.
Acha, can 4.
Well, another thing, Millard, I must point out, by virtue of order dated 20th February 2025, the Honorable Court has pleased to direct them to file additional documents if they are in possession
My lord,
of.
kindly excuse me for a minute, my lord. Can I bring that copy? That is ready, my lord.
Come back at 1 or 2 o'clock.
At 2 o'clock, I have some difference.
Today only can 4 will be allowed. Nothing much more will happen.
I'll be placing the additional.
Place the additional documents. Your name will be recorded in the order. চলো আমরা ঘুরে আসি।
I'm deeply obliged, my lord.
we'll get a copy of the additional documents from them.
For everything you need court's order. You are.
Served, I'll serve once again, my lord.
You
I'll
tell
serve.
your learned friend, he'll give you.
Court's order.
Acha.
Correct.
We have adjourned it.
Yes, madam. Returning on 17th.
কবে কি হয়েছে বলো?
On
13,
17th, it has been fixed.
তাহলে 17ই রেখো না?
24th, I have talked with the other side. I
17ই
also
রেখো না?
got the other side also.
24 রেখে দাও তাহলে।
Fine. And only none appeared that maybe.
কি না বলেছি কিছু অর্ডার ফর্ডার
None
হয়েছে?
appeared on behalf of the.
অর্ডার করো না, 24 তারিখে রেখে দাও।
Fine, fine.
My lord, praying for apology, my lord, with regard to item number 16, my lord. My lord, sorry, my lord, I was unable to appear before your lordship, my lord. Your lordship was pleased to dismiss for default the matter, my lord.
16?
Yes, my lord.
16টা কে শোনো কে ছিল বলে দিও, 16টা অর্ডার না করতে, নট টুডে করে রাখতে।
Grateful, your lordship.
ডিডি হয়েছিল।
Grateful, your lordship.
করো করো চলো।
কমার্শিয়াল 1 নম্বর।
ও ক্যানফোর্ডটা দাও, এই যে দেখো, এই তন্ময়, তোমার দাড়িটা কোথায় গেল? ও আফটার শেভ ইউজ করতে হবে বলে দাড়ি কেটে ফেলেছে। Very good.
Subject to what calls from your lord.
The appellant's suit against the executive engineer, Bankura Highway Division, PW bracketed roads bracket close Directorate, Nutan Chanti, District Bankura, was dismissed by the learned trial court. Stop. Hence this appeal. Paragraph. One of the grounds for dismissing the suit was that the state of West Bengal was not impleaded as a party defendant. Stop. The executive engineer was the sole defendant. Stop. The present appeal has been filed assailing the dismissal decree. Paragraph. This application has been taken out in the appeal for impleading the state of West Bengal.
Not only that, for also amendment of plaint, that perhaps.
Sorry?
Also for amendment of the plaint, but perhaps that cannot be, is not possible. The prayer is twofold. One is impleading, amending the cause title.
Can be done, can be done.
Until and unless
Even
it
after
the nature and
dismissal.
character of the suit, my lord, it can be done, my lord. Even at the second appellate stage.
Yes, it can be done.
In that case, may I?
But for that, you should apply before the learned trial court.
Well, it won't change the nature and character of the suit, my lord.
That is
all
all
the evidences
right.
are on record, my lord. The appeal can be heard out along with the, my lord.
May I come back on that point?
If it
What
raises,
point?
my lord, if the amendment
This
raises,
is nothing on merit, sir. Why are you wasting time on this? কি বললো? Impleading corona, for amendment of the cause title of the plaint, as also of the memorandum of appeal, by impleading the state of West Bengal as a defendant oblique respondent. Stop. Paragraph. The amendment sought for is of a formal nature. Stop. The same will not change the cause of action or nature of the suit in any manner. Stop. It is well known that an appeal is a continuation of the suit. Stop. The appellate court has the power to direct amendment of the plaint. Stop. Paragraph. We are inclined to and do allow the present application. Stop. let the memorandum of appeal and let the cause title of the appeal papers be, the trial court records have not come.
My lord, there was a direction to disclose all the documents by way of affidavit, my lord. That is ready, my lord.
Have the trial court records
No,
come?
my lord, no. It hasn't been called for.
Let the trial court records be called for. Once they arrive, the department here will amend the cause title of the plaint.
My lord.
Will be appropriately amended by the department by impleading the state of West Bengal. Which department?
Hello. Paper book department, my lord.
Through the secretary, PWD,
Oh,
Public Works Department, as respondent number 2 in the appeal. Stop. Let copies of the cause title, amended cause title, be supplied to learned advocate on record for the respondent. Stop. Paragraph. Let the trial court records be called for. Stop. Once the records arrive, comma, the department shall also cause necessary amendment to the plaint of the suit by impleading the state of West Bengal through the secretary, comma, Public Works Department as defendant number 2 in the suit. Can 4 disposed of. That is all.
Direction with regard to the deposit of special messenger cost, my lord.
ওই যেখানটা called for, ওখানে লেখো, the appellant shall deposit special messenger cost with the department for expediting the transmission of the trial court records to this court.
May I only say this, my lord,
Comma, will deposit special messenger cost within a week from date.
But my difficulty is, my lord, once, my lord, the state of West Bengal is, my lord, added as a party, now they would perhaps, my lord, be able to say that the defect is removed. But my contention would be, my lord, that the institution of suit itself was bad in law and contrary to section 79 of the CPC, which provides that in a suit against government, the government has to be a media party, state of West Bengal. So, my lord, may I only, my lord, say this, my lord, lordship will kindly add, my lord, that this, my lord, my objections are, my lord, kept open. That
ওই
is
তাহলে inclined to allow এর আগে একটা করে দাও. Learned advocate for the respondent strongly opposes the prayer. Stop. He says that the suit was filed in violation of the provisions of section 79 of the Code of Civil Procedure. Stop. Such defect cannot be cured at the appellate stage. What are you filing? File.
My lord, since the LCR has been called for, my lord, earlier there was a direction to submit all the documents exhibited before the trial court by way of
Bunch of documents, last year, exhibited before the learned trial court, comma, filed by the appellant, be kept with the records. What are the other cans?
Man, one is for application for appropriate order that has been allowed. Can 3 I have withdrawn with liberty to file afresh, as a result of which can 4 has been filed, my lord.
1, 2?
And 2 is, my lord, with application under order 41 rule 27.
Along with the
Yes,
appeal?
along with the appeal.
What is can 1?
Can 1 has been disposed of, application for
Achha,
appropriate
yes,
order.
Can 4 disposed of.
Deeply.
Item number 3.
Wait, please, lordships. Lord, section 37 filed by us. We have prepared skeleton notes of submissions, and we have, my lord, annexed the relevant judgments with the notes. for the convenience of the Honorable.
Who's appearing for the Union of India?
That Mr. Shaturu Banerjee was appearing on the last day.
কি আছে অর্ডার আছে কিছু দেখি
That prayed for time, my lord, on 20th of May when the matter was taken up.
Can Ford dispose of?
Yes, sure. So what should we do? You want to proceed in the absence of the other side?
I leave it to your lordship.
No, don't
Can
leave
come
it to us. We are happy to hear anybody, ex parte or in the presence of the other side. But this is also not fair. Somebody should have been here. You proceed, I think.
Very grateful. But may I request your lordships to take up the skeleton notes of submissions, because I'll indicate very briefly what is the background, and then I'll indicate the award and the 34 order.
34, you are the award holder.
But I'm not the award holder, the award debtor. Part of it was given in our favor. There's a finding, and I'll indicate why it is, my lord, it satisfies the ingredients of a section 34 and how the court did not appreciate that in the section 34 proceeding. May I, without going into the merits, and before I indicate from the notes, may I indicate what is the portion of the award which is so blatantly illegal and violates.
You were the claimant.
We were the claimants. We were the claimants. May I indicate what the matter was? There was a tender which was floated on July 9, 2010. So this work was for welding of rails by using the railway premises at the welding plant at Jharsuguda. That was the work, my lord, which was given. There was a letter of acceptance. We accepted. We carried out the work. While proceeding with the work, there is an issue with regard to fluctuations in voltage. That is not within our control. We carried out the work. While this was being tested, there were failures in the wheels because this was a welding work. When this was being done, if there's a fluctuation in the voltage, then the machines will not work. We had shown at the second stage when we brought in our own generator set and where the voltage was stable. Very briefly, I'm encapsulating what the fact was. That the voltage was stable, the machines kept working and the welding happened. So these machines which were made by us, it is not that they were faulty to begin with. But the tests and the voltage is beyond our control. That is for the railways to give. The main grievance which I'll show from the records is there were 4 hearings in the arbitration proceeding. The arbitral tribunal was not constituted properly. It was a unilateral appointment because the tribunal post 2015, after the amendment, thereafter the appointment of the tribunal, the reconstitution of the tribunal was in violation of section 12. That was not considered. The point was raised, it's a point of law. When we raised this point in the section 34 proceeding, the learned court was of the view that you have not taken this point before, so you can't be allowed and permitted to take this point now at the stage of section 34.
Which court?
Alipur Commercial Court. And that was the reason. It's a point of law. We had argued that there can't be an estoppel against law. This is a point of law. We have judgments which say that this aspect has to be considered.
Yes. We expect somebody to be there for Union of India when the matter is taken up. On several locations you took time. 20th of May you took time. Today when the matter is called on, nobody is there. If this is how the cases of Union of India are handled, very sorry state of affairs. Are you in a position to do the matter today? No question of let them. Are you? Then we'll call. I will hear you first. So you are not in a position to proceed. Mr. Bagh, let's not have it piecemeal.
Because I'll take some time and I'll finish in one day. Within an hour, I'll finish.
Then proceed. He's coming. We have been assured.
Or if it falls, if they want, I can come back on any other day, whatever suits the
Then
honorable.
come back next Tuesday.
We'll do so. We'll do so.
Come back
Because
on
my notes are ready. I have annexed the judgments to the notes, and I'll indicate. The main premise is this: one point, it's a violation of section 18, and I'll indicate why. There were 4 days when the hearing happened in the arbitration proceeding. It ended in the year 2018. There was a direction that you can give documents if you want to. That documents on record was given in 2019 unilaterally to the arbitral tribunal. We didn't have a chance to deal with those documents, and an award is
Well,
passed.
if you succeed on the point of violation of 12 read with 7th schedule,
My lord.
7th schedule, then we did not go into the merits.
There are other points, my lord, where these are all pointers which are, my lord, in our favor, because this award
The
cannot be
arbitrators were employees of the railways. Arbitrators?
They were employees of the railways.
Employees of the railways.
And
appointed after the amendment.
appointed after the amendment.
কি কথা থাকবে তাহলে?
And the only point is not because they say we have not taken this in the courts of the arbitration proceeding. It was 4 hearings, only 4 hearings. And the documents were given by the other side to the arbitral tribunal after, my lord, the hearings were concluded. We didn't have a chance to deal with those
The waiver has to be by an agreement in writing, express agreement in writing.
It's not, and that is our main grievance, my lord.
And BSNL recent Supreme Court decision.
Lordship, we're carrying that. We're carrying that.
And there's some Bombay High Court decision, we are told, in another matter we were told, which considers all Supreme Court decisions, including BSNL. And we are told it's a very, very learned judgment. So try to get that also. কে বললো বলো তোমাদের? কে ছিল তাতে?
BSNL is 2019 5 SSC 755. We are carrying that.
Yes, but later Bombay High Court judgment. Huh?
Not aware.
One of your learned friends told us, I've forgotten who. Oh,
with a lot
Mr.
of enthusiasm, my learned juniors indicating that Mr. Shatru Banerjee is on the side. He is the one who has indicated in the morning about this Bombay High Court judgment. I don't.
Mr. Loknath Chatterjee.
My lord.
Loknath Chatterjee.
I'll get hold of the judge.
Yes.
I will do so.
All right. Acha, dekho. Mr. Bagh, learned counsel appearing for the appellant, opens his case. Stop. We have heard him for some time. Stop. Paragraph. Let this matter be listed again on Tuesday date the other.
Very deeply obliged.
After we have dictated the order, Lekho, Mr. Shatru Banerjee walks into the court. Lekho na.
Lordship can. Lordship is keeping it on bench.
Tuesday.
Tuesday.
Very deeply obliged.
Oh, BSN. Was the judgment against me, that one that we showed.
Yes.
Oh my God. Then I should give in the Bombay High Court also the other one.
Give it to him.
I'll give it to him, my lord. But এখানে তো employee ছিল না? তো আগে ছিল। But this is a little different. He was once upon a time an employee. Not, my lord, an employee like in the other matter which lordship is.
We haven't applied our
Yes,
mind.
that is why I'm saying, my lord. I think now there is a distinction made, my lord, by the Supreme Court even to these matters where he was once upon a time, my lord, acquainted with the institution and all.
Yes, but that he disclosed. That is.
Yes, my lord. That is disclosed, my lord.
Great. No waiver. I'll indicate that.
No, maybe, my lord, here that waiver is not required. Here that waiver is not required.
Deeply obliged.
Great. Good.
হয়ে গেল appellate side.
We don't need to.
Why to be mentioned?
Your Lordship, Director to fix the date for hearing.
Fixing a date
early
of the
he-
hearing.
Because this is that matter, after the
I'm appealing for the appellate, Lord. Silent reason. You can hear, you speak. Yes, my lord, I'm appealing for the appellate, my lord.
Next Wednesday, would that suit you?
My lord, can it be sometime in July?
Yes, it can be.
I'm coming before your lordship on 9th of July. Can it
Oh, you are coming on the 9th, correct, you're right. Let this also be listed on the 9th of July.
after obtain the interim order passed by your Lordship also, kindly see the order, they have surrendered the premises, to the board trust directly.
Mr. Ghosh is indisposed.
Online he is available.
Online, we find it difficult, very difficult.
One appeal is impacted because they have surrendered the premises to the directly to the port trust.
Then
After obtaining, only for they have
Then let us release it. You go before some other court. No?
No, your Lordship fixed.
9th of July. 9th of July.
Otherwise, I will not.
9th rekhe dao, 9th.
They have not taken any
9th of
steps to hard out the appeal.
9th.
Grateful, my lord. Deeply obliged.
Let these matters likhe dao, doctor. Let these matters be listed under the appropriate heading on July 9.
July 9. Grateful, my lord.
Item number 3.
Yes.
Your Lordship, this is a restoration application, Your Lordship. ACO 1 of 2020, Your Lordship. The matter was dismissed for default. It appeared as under the heading Old Matters, and the erstwhile advocate on record expired, Your Lordship. I was briefed only the day before the matter was appearing in the list, Your Lordship. In the second call, when the matter was taken up, there was a resolution of the bar of not attending court, Your Lordship. So I was also not present, and the matter was dismissed for default. Your Lordship, I was praying that.
Lord, there are two connected. I'm not on the other side. There were two connected appeals, my lord. My lord,
If you're not on the other side, on which side are you?
my lord, I am also for the petitioner, my lord. I have filed a restoration application.
Whose appeal is there? OCT 1.
It is my appeal, my lord.
That was dismissed for default, Your Lord. As well as
Both the cross appeal and the appeal.
Both were dismissed.
We are recalling that order.
Deeply.
Have you served?
Served to my learned friend, Your Lordship.
Oh. You're for Hungerford?
I am for the Turner Morrison and Company Limited.
Oh, you are the appellant.
I'm the appellant.
Who are you for?
I am for the KK Biani. He was the respondent, Your Lordship.
The cross objection. Very good. Then we'll restore only the cross objection. You have not applied for restoration.
Also.
We have also.
It is also appearing. ACO 5 of 2025.
And my is ACO 1 of 2025.
On the same date, both the appeal and the cross appeal were dismissed by your lordship, my lord, on 29th of April.
কি দুটো application আছে, দুটো restoration?
ACO 5.
ACO 5 টাই আছে. Your application is not here.
Of 2025.
It's not here.
My AC has also been filed, Your Lordship. If Your Lordship can treat it as.
No, we can treat on raised lists, but have you filed? We don't have anything.
I've got the number ACO 1 of 2025, Your Lordship.
As on raised list করে দেওয়া যাবে, হবে না, তাছাড়া সব ঝামেলা আছে. The CIA system is very tricky. Unless it is listed, We can't do it.
Then in lordship, then keep it on Monday. Then your
If we recall this order,
lordship of the purpose. Then in that order, your lordship kindly meant that OCT 1 of 2018 will also
yes,
restored to its original file. Then
yes,
it
because
will-
we had dismissed both the appeals.
Correct. Your lordship in the same only one order.
Here you-
Your lordship,
This is an application for recall of an order dated April 29, 2025, whereby of 2017 and OCOT 1 of 2018 were dismissed for default. So, paragraph. Having heard learned counsel for the parties, we are satisfied with the explanation furnished for absence of learned advocates for the parties on the day the matter was dismissed for default. The matters were dismissed for default. Paragraph. Accordingly, the order dated April 29, 2025 is recalled. Stop. APO 283 of 2017 is restored to its original file and number along with OCOT 1 of 2018. Paragraph GA ACO 5 of 2025 is disposed of.
kindly dispose of ACO 1 also. Otherwise, it will appear.
That won't, no, then that can't be put on the server because that is not in the list.
That date. Hopefully,
কালকেই দিয়ে দাও ওটা কালকে ডিসপোজ অফ করে দেবো হ্যাঁ মনে করিয়ে দিও যে ওটা এমনি ডিসপোজ অফ হয়ে যাবে list the appeal 1 week hence.
Lord, after
No, anytime in July, my lord, not 1 month.
July, your lordship.
List the appeal in the first week of July 2026. Twenty-five.
Item number 4.
For the appellant petition.
We will not injunct the meeting. Mr. Jishnu Chaudhary was here yesterday.
My lord, we wanted a stay of, my lord, my suspension.
Therefore, that it has established heard out, Mr. Banerjee, what we will make clear is that if you succeed in your appeal,
yes,
we'll consider permitting you to participate to contest the election.
Then, my lord, let my nomination be filed, my lord, subject to result of the appeal.
Everything will be allowed then. If you succeed, if your suspension goes.
But unless I participate, my lord, in the elections will be held. Because generally, my lord, these elections were always held in November, December, or my lord, earliest was September. I found, my lord, the earlier years. All of a sudden, my lord, now it's being held in July.
So why don't you argue the appeal itself?
I'm ready, my lord. I can start. I can start.
Let us just run through the list once and we'll take up your. Huh? Oh. Lista call করে
Item number 5.
My lord, this is my application. I'm a respondent. My lord, an order was passed, my lord, in 2015 in a contempt jurisdiction. My lord, I'm a clearing agent. And my lord,
you're Sharat Chatterjee?
Yes. My lord, in Visakhapatnam, clearing agent, a receiver was appointed to sell coke lying in port warehouse, which is leased, which I've taken on lease. And my lord, there were two rival parties claiming interest in respect of such coal. One is Dankuni and the other is LMG. My lord, I am the clearing agent. I have no control. So
who is Dankuni?
Dankuni has gone into liquidation. Now,
Well,
Concast and Dankuni are one. They are represented by the official liquidator now. My lord.
And LMJ?
I appear for the other.
Now, what has happened, my lord? In spite of 2015, an order passed by bench consisting of Justice Chelur and Justice Joymal Lobakchi, appointing a particular receiver, member of the bar, to sell these goods, remuneration to be shared amongst these two people, 50-50. Till date, the goods have not been sold by the receiver. Now, my lord, there is in the order specifies that when you sell the goods, the accruing port charges.
Etar application ta ache to.
Yes,
No.
I'll tell you, it was filed in 2018 and kept pending. It has come up, and 30 my lord. The till date it has not been filed, and the goods were supposed to be sold by public auction, and out of the proceeds, the port dues which are accruing, at least the port dues in respect, would be first paid.
What is your stake in this matter?
My stake is the goods are lying in my warehouse. The goods are not being cleared, being sold.
In your warehouse?
In where which has been leased to me. I have taken on lease from the port.
From the port?
From the port. My lord, the port charges have accrued to over 3 crores, my lord, over time. After that, my lord,
Mr. Bose, kindly indicate which is the order by which...
my lord, just two things, my lord. In the meantime, after great effort, my lord, after a lot of steps being taken, the receiver took steps and ultimately published a wholesale notice in 2017, and sale was confirmed by bench presided over by Justice Nishita Matre, my lord, in 2017. Aggrieved with that, LMJ, my lord, went to the Supreme Court saying you could have got a higher value. Why? Because at the end of the day, rival contestants are claiming interest over the goods. I have a claim, etc., etc. So if you are getting it for a small claim, my lord, I will get more goods. And the Supreme Court said, yes, I agree. You could have got a higher claim. You must specify how much is on account of customs duty, which is payable, etc., and then sell, and gave direction and disposed of the special leave petition, directing the same receiver to immediate take steps for the purpose of sale in 2017. Thereafter, what has happened? Letters and letters and letters, meetings and meetings and meetings, and this special officer at times is saying revaluation, do revaluation.
No, so do I understand correctly, Mr. Bose? Once sale was held and confirmed by a division bench of this court.
It was
carried in appeal by LMJ. The Supreme Court set that aside
and said again, directed afresh the same receiver to do Millard. And ever since then, Millard, if the receiver doesn't want to do it, please, Millard, remove him. Remove him. This order of your lordship must be complied with. That is all I say. I will show you now.
We shall no. We shall simply call for a report immediately from our receiver.
Millard, please do something, because I neither can go to the Supreme Court, file a contempt, because I filed it in 2018. First, the issue came that the company has gone into liquidation, one of them. Steps were taken to amend the application. Amendment was carried out, which was opposed by LMJ. My lord, I do not mind LMJ taking the goods or Dankuni taking the goods. I want the godown to be cleared, because my port charges is accruing each day. My lord, please do something.
Yes.
Instructed that the receiver has already taken steps. He has already taken.
We want to know from him what he has done.
My lord, and until it is actually sold, please do not release the matter. I am besieging your lordship.
Why should we release the matter?
No, dispose of the matter, that he will take steps. And that is exactly what the Supreme Court, my lord, with great respect, did in
Please.
2017.
Please indicate where this order of Justice,
Yes,
Chief
my
Justice Chellur and
Yes. My lord, may I show you the portions of the order? I marked it, and the Supreme Court order.
page 19 is a contempt jurisdiction order.
Yes, it was, my lord, I will tell you, I am not going to the checkered history, but the facts are indicated in the order itself. My lord, may I show you page 19?
No, I've got it. We have got page
My lord,
26.
may I just throw portions of the order?
Not necessary today, Mr. Bose. We will see if necessary. এসো তো এদিকে।
But at least page 26 may be relevant.
Yes, that is the direction. I've noticed that.
The last
in this backdrop, we are of the opinion that a special
well, at
officer.
page 25 and 26 will, if you see the entire thing.
So page 33, well, there is a direction what the receiver. Lordship, may I indicate one thing, Lordship? Page 30, Lordship will come to page 32 once. Page 32. Last paragraph. Lordship, this was the Tricone suppliers was declared as a last paragraph, 10,000 metric tons, Lordship. He was the successful bidder, Lordship. The next page, Lordship, will see that the second paragraph, Lordship, that the respondent one shall provide the details of the statutory duties, taxes and other charges to be paid to the total sale value to the special officer within a week from the date it was a direction. The balance quantity of 1465.9 metric ton met coal shall be delivered to the appellant, to us, Lordship. Now, the Lordship, the client of Mr. Bose, he is saying that it's not there.
You are for Dankuni?
I'm for the Dankuni.
Official
I'm for the appellant.
He's official liquidator.
Official liquidator is supposed to get it because the dues are there from the other person's Lordship, which has to be paid by the.
Not followed. Appellant was Dankuni in that matter.
The company, now the official liquidator has taken.
Dankuni has gone into liquidation.
Dankuni and it's part of the Concast group of companies. Mela, Concast has gone into and Dankuni.
Today, nothing excepting we are calling for a report, nothing.
Mela, please look at the orders. Your Lordship will,
Yes.
whatever it is, your Lordship will please do something. You want to see the Supreme Court order, Mela?
It's there, we have found it.
Yes, Mela. After that, nothing, just nothing.
দেখো তো। A judgment and order dated July 29, 2015 was passed by a coordinate bench in CC number 16 of 2014, bracketed out Dankuni Steels Limited versus Ajit Kumar Bothra and another.
Millard, along with
Bracket
APO
closed.
number 293 of
Bracket closed.
2014.
With APO number 293 of 2014, comma, CS number 77 of 2013, bracketed out Dankuni Steels Limited versus Sharad Chatterjee and Company, CO, bracketed VSP, bracket close, Private Limited and others. It a page 19 above it. Comma, the relevant, now the portion of which is relevant immediately reads as follows. কোলন দিয়ে আমি মার্ক করে দিচ্ছি page 25 থেকে 25-26 get out করে দাও paragraph. It appears that after some delay, comma, who is the special officer, Mr. Bose?
My lord, your lordship will find the name.
Yes, where will I find?
27. At 27.
Mr. Robi Prasad Mukherjee.
My lord, at the last portion, page 27.
You will know. comma, the special officer took steps for sale of the concerned goods, concerned coke or coke, C-O-K-E.
Miller, if you're looking at 27, just see the last line of 27. Even the remuneration was to be paid by the appellant Dankuni and respondent LMJ. If today the question is that you are not paying or that I'm willing to do anything as per your lordships.
Steps for sale of the concerned coke. Stop. Sale was sale of 10,000 MT. Sale of 10,000 MT of coke was confirmed in favor of one Messrs. Tycoon, Tycoon, Tycoon Suppliers Private Limited, by a coordinate bench by an order dated May 15, 2017. Stop. Paragraph. LMJ International, that is your name.
Now it has name has changed to what?
Shri Muni Suvata International.
LMJ International Limited, bracketed, now known as? Why don't you write down the name and give it?
Muni Shubroto.
Muni Shubroto. Baba likhe di. Now known as likhe di jate hue.
Agri International.
Carried the said order of confirmation of sale to the Honorable Supreme Court. Stop. By a judgment and order dated December 14, 2017, the Honorable Supreme Court set aside the order of the High Court, stop. The operative portion of the order of the Honorable Supreme Court reads as follows, page 47, paragraphs 14 or 15, set out. Paragraph. Today, Mr. Bose, learned senior advocate, appearing for the respondent number 1 herein, says that after the Honorable Supreme Court passed the order in December 2017, nothing has progressed in the matter of sale of the concerned coke. Stop. Numerous meetings have been held. Stop. Voluminous correspondence has been exchanged. Stop. But no real work has been done.
The real work, once valuation was done, he says again do a valuation. Thrice valuation, like this
but
is
no
happening.
Effective step. Real work, no effective step has been taken. Paragraph. We deem it appropriate and hereby do call for a report from the learned receiver as to the steps he has taken in terms of the Honorable Supreme Court's order for disposal of the concerned coke lying at the warehouse taken on lease by the respondent number 1.
Yes.
From the Kolkata Port Trust.
No. From the Visakhapatnam Port Trust, and also, it has been on it in Ripley go down. Ripley. Millard, please mention in R5 and Ripley, as mentioned in the order itself.
It's just in the go down.
In the 2 go downs.
In 2 go downs taken on lease.
As indicated in the order.
By the respondent number 1, as indicated in the earlier orders.
Yes.
Let such report with supporting documents, comma, if any, comma, be filed within a fortnight from date. Fortnight মানে কত হচ্ছে রেটটা দিয়ে দাও আজকে কত 12-26 comma stop. This matter will be listed again on June 26. Stop. Paragraph. Learned advocate on record for the respondent number 1 shall communicate this order to learned receiver immediately.
My lord, wherever your lordship has used the word receiver, please make
special
it
officer.
special officer.
Receiver টিকেটে যেখানে যেখানে বলেছি special officer করে দাও।
আর কিছু বলবি?
Item number 6 and 7.
But 6, I appear for the appellant blood.
Kunta. Altamas, I'm here.
Oh, I'm sorry.
And for the respondent, that I am led by Mr. Dev. Today morning, we have been instructed to appear in these matters. Six or seven.
না কে এটা মুভ তাজ ডক্টর তাজ Well, I am for one of the appellants and Mr. Shumon Dutt is for the other appellant. Movement. But anyway, Mr. Dutt spoke to me, he won't be stuck, so we
That's fine, but she has been recently
someone else.
for the respondent.
Mr. Bed,
Mr. Dev, Sudip Dev,
so you appellant which party?
for the respondents.
There are 100 respondents. There are. My application is for pro interest or so.
We are for all of the respondents.
All the respondents.
Mr. Shonjoy Bed has requested me that he is for, very well, maybe, let them come for the respondents. I was praying, my lord, keeps it on the 9th of July or after that, because there's Muharram and our client was in some difficulty to come. And there's a change in advocate on record. They signed the wakalatnama, they've given the consent. In the meantime, we'll complete the formalities.
Sort out those things. Accommodation is paid for on behalf of the respondents.
In both the appeals then?
In both the appeals. একসঙ্গেই করবে 6 and 7. Paragraph. As suggested by Mr. Dhruvo Ghosh, learned senior counsel, representing the appellant in
APO 489 of
APO 489 of 2015, comma, let these matters be listed again on July 9.
Grateful. Item number 8.
Well, this is my application. It was for disclaimer. My lord,
for the official liquidator.
My appeal from an application for disclaimer where I had, my lord, not been successful. My lord, the official liquidator had filed a supplementary affidavit. My lord,
Want to
bringing on
respond
record
to it?
certain facts. I have already responded. I've prepared my affidavit.
Give him a copy.
I have to copy though. And these are the photocopy. My lord, I'm serving a copy. Any day the matter can be fixed, my lord. Hearing.
The appellants, you're a company in liquidation. No, that's the OL.
OL.
You are JP.
I am JP, my lord. I have my property which I'm seeking disclaim.
You are the appellant.
I'm the appellant.
The appellant's response to the supplementary affidavit filed on behalf of the official liquidator, comma, be taken on record. Paragraph. As suggested by Mr. Mukherjee, learned counsel appearing for the appellant, comma, let this matter be listed again on
next week, whenever your lordship.
Next week, my lord. I do not have any.
Next Thursday?
Next Thursday.
They are occupying your premises.
My lord,
No, my lord,
premises,
premises has been
my
occupied.
case is that from premises is still in my occupation, but my lord, I need the property to be disclaimed. My lord, they are saying that there's a fraudulent transfer, by which, my lord, I had entered into an agreement to take the property of the company in liquidation. My case is no, it is not a fraudulent transfer.
Prior to 6 months, my lord, this property was transferred. By way of agreement for sale, no registered deed.
The lordship will
All right.
into consideration.
I'm deep.
You'll.
Password matter item number 4.
The next one was, my lord, we were also arguing. So that's why, my lord,
Which one?
next one also, my lord, we'll do 4 and 9. My lord, 9 was the one which my lord was hearing, my lord.
Oh, yes.
That order to rule 2. There's been, my lord, a very tragic plane crash.
Yes,
Perhaps, my lord, has not
250 people.
242 on board.
Where-
Dreamliner, Ahmedabad,
London.
Ahmedabad to Gatwick, London, just took off and, my lord, crashed immediately.
Ahmedabad airport er kache.
Huh?
Ahmedabad airport er kache.
Dreamliner.
Dreamliner.
These are all very old Dreamliners, Mr. Banerjee.
Crash করে গেছে।
Just the crash at about 2 o'clock. News is, my lord, just circulating now.
Good Lord.
Very sad. And I believe, my lord, the ex-chief minister was also on Rupani. Also on board.
Dreamliner.
Tragic, my lord, that
Dreamliner.
this makes you
It can happen to anybody, anytime.
makes you feel so vulnerable.
Yes.
Ahmedabad airport
Ahmedabad,
take off
just-
করার পরই within 5-10
If you think about that, club membership pales into insignificance.
True, my lord. Absolutely correct.
Honestly.
Absolutely. Lot of things, my lord, will
Yes.
pale into, my lord, insignificance. Everything, in fact.
Everything.
Everything. Today I'm arguing here, tomorrow I may not be there also arguing. So, my lord, that way, just everything is
242 people on board.
242. And I just read, my lord, one of the reports says 200 dead. I don't know, my lord, whether that's correct, but that's very.
It's just happened.
Just happened. It's still showing, my lord, videos of, my lord, very tragic, and it's very close to anyone traveling anywhere.
Normally, air accidents happen while landing.
Landing or takeoff, my lord, I'm told that the first 5 or 10 minutes of, my lord, aircraft taking off or wanting to land is, my lord, one of the most dangerous moments of the aircraft's whole flight.
Better not to take off.
No, don't say, my lord, better not to land. At least better not to take off is better.
Yes.
Sorry, my lord, we have to come back, my lord, to this social, my lord, stigma of, my lord, being suspended, my lord, from a club where I was the ex-president and now a member. My lord, tell me, my lord, what had happened. My lord, there are accounts of, my lord, 23-24. I had raised, my lord, I was one of the ex-presidents of the club. I'm also a member. And in terms of their, my lord, articles, I become a life member. I raised, my lord, certain issues by way of a WhatsApp for the accounts of 23-24. The accounts, the issue.
When were you a president?
No, that I was, I'm a previous president. Previous president. My lord, 2-3 years back, my lord, I think during COVID times, my lord, I was president. I raised, my lord, certain issues with regard to, my lord, the present accounts, pointing out that there were discrepancies, and which are, my lord, also I'll show, my lord, the position as it emerges, admitted position. Discrepancies with the previous year's accounts, with certain figures. I raised it by way of a WhatsApp, which was circulated to all members. In the Gen meeting itself, some other members also raised similar issues, and all these issues, my lord, were discussed. And, my lord, according to me, discussed and explanations were given by the present committee, and then, my lord, resolutions were passed, and, my lord, the accounts were approved. Thereafter, and this is, my lord, of September 2024, thereafter, notice came to me with regard to asking whether I'm the one who circulated the WhatsApp. It's not, it was a known fact that I circulated WhatsApp or not. Then that's how the procedure started. I said, yes, this is my WhatsApp. I was called, and I'll show the procedural lapses. I was called, and then there's a membership. There was a committee.
Is it understood that we are hearing out the appeal? Are all papers here?
All papers here.
Yes.
Well, only thing is, for the record, they had submitted their notes of submission. We have put that by way of
that they won't object to. Yes.
Copy করে দিয়েছি তোমাদের। হ্যাঁ, খালি notes, তাই বলছি আমি দেখিনি।
This is in part of the appeal. No, this is part
13. This one number 13.
Huh?
This one number 13.
This one number 13. So, appeal member refusal to pass identity order. That has been done.
Yes.
Affidavit has been given. Matter is adjournment listed. You was the last single judge. Everything here.
What affidavit is? No.
Your clients have filed affidavits.
No, affidavit can file hide.
Not in affidavit. No, in the yes, single judge. No issue.
Affidavits have not been filed.
In spite of directions.
Yes, so affidavits have not yet been filed.
To answer my learned, I think that answers my learned friend's point also, that directions, no affidavits filed. And at interim stage, I agree because this is a suspension in a club is a social stigma, which if I can show a prima facie case in my most humble submission, it should be stayed. It should be stayed till the suit or the application is heard out. So as I was explaining, so this happened, then there were a lot of correspondence going on. Then they had a meeting through one of the sub-committees. It was called member relationship committee. Then in the member relationship committee, they were supposed to ask me some questions, frames. Sorry, I'm so sorry.
Yes.
Supposed to ask me some questions, then they said this meeting will be video recorded. We wanted minutes of the meeting. I'm just giving in brief, then I'll come and show all the we wanted minutes of the meeting because there's a lot of correspondence with regard to that. They say, no, you treat the video recording as minutes. Then there's a questions which were put to me through now the executive committee. And I don't know how the questions came to be formed because the membership relationship committee did not frame the questions. We have now a transcript of the entire video recording. After that, when these questions framed, we said that we must have the minutes of the meeting, whatever happened, whatever transpired there. That's not given to us. And then we are suspended by the executive committee. We have raised.
When was the suspension order?
The suspension was on 30th January 2025. We filed the suit on 10th February 2025. And we asked for stay of that suspension.
No show cause in
no
hearing.
That's one of the grounds taken. No show cause notice, nothing. So the three grounds which we have really taken, that we also have to know on what ground you want to suspend me. So there has to be a show cause as to what is the charge really or putting on me for me to be suspended by the committee. Secondly, we also took a point saying that the grievance which we had raised is already addressed by the general meeting itself in September 2024. Where is the further cause of action to pursue against me after you yourself have dealt with the questions? So there has to be a surviving cause for you to say that why did you circulate this or why these were not correct. So in the gen meeting, you should have itself said that, no, sorry, this is all frivolous. And why have you circulated it? Because this was before the gen meeting. So after that, my lord, it is done.
So are you saying that the grievance that you raised
Yes.
regarding the accounts, that was discussed
Yes.
and addressed at the general meeting?
Yes.
How it was dealt with, you don't know.
Yes, yes, my lord. We have got minutes
Right.
of the general meeting.
So your grievance was brushed aside or rejected?
No, it was, my lord, considered. Some explanations were given.
I see.
Whether, my lord, the explanations are correct or not is really, my lord, not the concern here.
Yes.
Because thereafter, my lord, I did not do anything.
Right.
And I will also show, my lord, the grievance which I raised, which is apparent on the face of it, because what they had done, my lord, in 2023 accounts, my lord, there were certain figures which they changed in 2024 as to the previous year's figures. And which was on the face of it, my lord, obvious. According to them, my lord, they had, my lord, merged this account, these figures or changed whatever, my lord, they wanted to do. But what I'm saying is, my lord, whether there was really a cause which survived the gen meeting for you to then pursue it against me and suspend me. So that's one of the points. Secondly, my lord, whether, my lord, you could have done this without issuing any show cause notice and without really telling me you're going for my suspension. Now, my lord, I would first like to, my lord, show, because, my lord, issuance of, sorry, my lord, just one, my lord, submission. Issuance of show cause notice or, my lord, putting me to notice would be even here, because, my lord, this entails a consequence of, my lord, a social stigma. It's really, my lord, in that sense, in a club, when you're suspended, it has some consequences. Will be a facet of, my lord, the principles of natural justice. Because suspension, my lord, itself amounts to, my lord, a punishment. Now, kindly first come to page, my lord, 326, my lord, how it started. Before that, just give me that comparison, 318. I'm sorry, my lord, just before that, my lord, may I just show one thing? What, my lord, we were, the comparison. My lord, kindly take, my lord, 318 once, my lord, page 318. My lord, these are the accounts. Yeah, I've got
318.
318, my lord. These are the accounts of, my lord, 31st March 22-23. Then kindly come to T20. My lord, if, my lord, there is any difficulty in reading that, we have, my lord, a more legible copy, my lord, of, if, my lord, there is any.
No, I can read it. What is it? We are not that old.
No, my lord, that I'll never say. That will increase, my lord, all of our ages. Only, my lord, for purely selfish reasons, my lord, we are not going to agree. Yes. My lord, kindly look at. I'll just give an example, my lord. On the left hand side, page 320, my lord, has that 320.
Yes.
And then, my lord, sees department surplus deficit, third entry.
Yes.
And, my lord, sees 31st March 2023 as the figure 176,91699.
Yes.
Now, my lord, kindly come to the right hand side where, my lord, the balance sheet of 31st March 2024 is there. And, my lord, looks at departmental surplus deficit net and kindly look at the 31st March 2023 figure. 147. It cannot change.
Yes.
It cannot change. When you have your 24 figures, your 23 figures which have been approved the last year cannot change. It has to be the same. And then Mulad sees profit loss on redemption sale of investment. On the left hand side again, Mulad. Oh, sorry, other income. Sorry. Mulad, other income. Mulad sees other income. The 31st March 2023 figure, Mulad, on the left hand side is 13125,811.
Yes.
And Mulad sees on the right hand side
55.
Yes. And Mulad, this is minus, and that has become Mulad plus 55. This was in minus, Mulad, in brackets.
Yes. Yes.
Then Mulad also sees administrative expenses. Expenses for children, sports and clubbing. Now, Mulad, administrative expenses on the left hand side, the original 31st March 2023 figure 375. And here, administrative expenses, Mulad, become on the right hand side 376. But Mulad, they have another heading, expenses for children's sports and club events. Which is not there, Mulad, in the 31st March 2023.
Administrative expenses has also changed.
Also changed.
Not very much, but little.
Yes. But Mulad, that heading with expenses for children,
that was not there.
That was not there.
Yes.
And there's Mulad one sports on the left hand side, which is only 76,960. Now that is not there. But Mulad, expense for children's sports and club events comes to Mulad 202. Sorry, 215. So what I'm saying is, Mulad, on the face of it, there appears to be an anomaly or a discrepancy.
Yes.
Now it's Mulad the same chartered accountant, and Mulad, there is no specific explanation as to why these figures have changed. Now kindly come to how this started. 324 kiya acha. Oh, I'm sorry, Mulad. Just one more topic, Mulad. One more topic. I'm so sorry. Mulad, in 324, there are Mulad discrepancies, Mulad, with regard to salaries, wages, and bonus. That was Mulad first shown as 254, 2 crore 54 lakhs 72,102. Now Mulad it becomes 2 crore 55 lakhs. Mulad provident fund is 820. The next one, it becomes 827 79977. Pension fund, Mulad, shown as 898,478, and pension fund shown now shown, Mulad, 906,621. Employee state insurance contribution 481,743, now shown as 486,109. Gratuity, Mulad, was shown as 10,101,2791. On the right hand side, shown as 10,21,970. And interestingly, Mulad, even rates and taxes also changes. 763 becomes 745.
Yes.
Legal and professional expenses. That figure, I don't know whether it's missing or not. It's 706. 431. It may be missing. That 7 may be missing. 706 413.
Yes.
And this year it has changed. The 2020 figures changed to 8,61,920.
Yes.
Even general charges, I find 1971483. It becomes 1815976.
Yes.
So in this, I now kindly come to and just one at page 325, there's one line which says previous year's figures have been rearranged, regrouped. 325 at paragraph 2 on the right hand side have been regrouped, rearranged, regrouped where considered necessary. Unfortunately, that does not give anyone the liberty to change the previous year's figures. Because this is there in all accounts, this is there. Now kindly come to page 326. This is what I am guilty of. This is what has now caused my suspension from the club by the present executive committee members.
Yes.
Subject calling members to participate in annual general meeting. So can you see to all the present permanent members of our club? Subject calling members to participate in annual general meeting to address pressing issues. Dear members, I do hope this letter finds you in best of your spirits and health. We are all valued regular member of our esteemed club. I am writing to invite you to participate in the upcoming annual general meeting scheduled to be held on 20th September 2024 at 11 at the club. It has recently come to light that there has been significant financial irregularities within the club, which requires immediate attention and collective discussion in an open forum. These irregularities raise concern about the financial management and transparency of our club, and it is imperative that we address these issues together to ensure the integrity and sustainability of club's financial affairs. To summarize some of them, more than rupees 8.25 crores has been spent on building, furniture and fixtures and equipment one financial year. Investment coming down by 2.5 crores. Gross irregularities in figures which were shown last year and brought forward this year. No explanation or schedule being provided to show the applicability huge money spent. No prior intimation or permission sought from members from venturing to spend over 8 crores in a financial year. Whether 3 quotations were invited before allocating work to a particular vendor. During the AGM, we will try to provide a detailed overview of the financial irregularities that have been identified, discuss their potential impact on the club, and collectively work towards finding solutions to rectify these issues. Your insights, input and participation in this meeting are crucial as we navigate through these challenges and strive to uphold the value of transparency, accountability, and good governance within our club. I urge you to mark your calendars and make every effort to attend the AGM on 20th September to contribute to this important discussion and decision-making process. Your active participation is vital in shaping the future of our club and entering its financial health and sustainability. Now, Mulad, this is what Mulad I have circulated. Then kindly see Mulad 327. This is 9th October. It says 10/9, but it's the American way. It's 9th October 2024. So AGM is held on 28th. I'm not given a minutes. The minutes was later put up in the notice board. And during the course of hearing, this minutes were looked at. So 20th, my lord, AGM is already held.
This 326 is dated. Which date was this?
It is, my lord, dated 23rd September 2024. There is no date on this, but that's, my lord, when it was circulated. Yes, by WhatsApp, which is, my lord, an accepted, my lord, position so far as we are concerned.
Yes.
Because, my lord, knows the generally, my lord, the notices when, my lord, the accounts are circulated. It is generally, my lord, supposed to be 21 days, but it comes, my lord, before that, my lord, 21 days for 15 days, whatever, my lord, it's time posted and all that. You get the accounts. Then, my lord, so AGM is held on the 20th September. Now, my lord, they write on the 9th of October. And this is, my lord, from, my lord, the CEO and secretary of the club. From secretary, such and such club to Mr. Sansaj, dear Mr. Surana, membership son. Please note that the undersigned has received a copy of a letter circulated over WhatsApp about 4 to 5 days before the AGM from one of the members of the club. On perusal of the same, it has come to the notice of the undersigned that the same has been issued under your signatures. Before proceeding further in the matter, the undersigned thought it would be prudent on this behalf to confirm from your good self whether the said letter has been issued by you or not. You are humbly requested to confirm the same to the undersigned by means of your response over the email. Please further note if the undersigned doesn't receive any response from your end within 10 days from this mail, it will deem that the same had been issued by you, awaiting your early response. That's all, my lord, is written. Then, my lord, kindly see, my lord, we respond. My lord, I take a little, my lord, umbrage because, my lord, only the secretary is written to me. I am writing concerning recent email received from you, which to my understanding has been issued without clear reason or authority. Paragraph 2 of your email mentions before proceeding further in the matter, there is no mention as to what is the matter for which you as the secretary in your own accord wishes to proceed further. Until proper clarification regard is provided, I refrain myself to answer a query and the same is without prejudice to my rights and conditions. As a past president of club, I was surprised to receive this communication, especially since it was issued suo motu and in own motion and thus without proper authorization according to the club's rules, secretary being deployed not as a part to unilaterally send such emails. Club is social enjoyment, such noted club is social ground based on laws of mutuality. Then, my lord, we can skip over. Then kindly see. Now, my lord, there's a membership relationship committee. The next communication, my lord, is on October 24. So he gives a notice saying, have you written this? Before I proceed further, we said, what proceed further? What is that you really want to proceed with? So please tell me about that. Then, my lord, we received this, 24th October. The WhatsApp, again, my lord, from the secretary. The WhatsApp communication dated nil found floated to the members of this class a few days prior to the AGM. Email of the undersigned addressed to you dated 9th October and your reply thereto dated 19th October placed before the committee. In the committee meeting held on 23rd October, the committee, after due deliberation, decided to refer the matter to the members' relationship committee, comprising of the following committee members. Then, my lord, they mentioned, my lord, there are about 6 of them. Then, pursuant to the aforesaid resolution, the members' relationship committee has decided to hold a meeting at 1800 hours on 20th October 2024, wherein you're requested to appear before them, membership relationship committee, to explain the contents of the averment made in the WhatsApp communication as mentioned in the email of the undersigned dated 9th October 2024. Minutes. Now, kindly see, next is 330. Transcript 452. The 23rd was held on 8th November. Now, my lord, can you see 27th? I'm in receipt of your mail dated 25th. My secretary and CEO of the club informed me email dated 9th October along with the reply to such placed before the committee, and after due deliberation the committee has decided to refer the matter to a members relationship committee and has requested me to appear at 1800 hours on 20th October before the said committee. I'm surprised at the use of the word appear for obvious reasons. It may not be out of place to mention that protocol demands that any letter to a former president ought to be sent on the aegis of the present president of the club. Be that as may, I was earlier surprised and I'm shocked at your conduct actions. Understand this reply did 19 question your part to issue such an email. So more to done into instance, further sought a proper clarification with regard to paragraph 2 of your email and made it clear, categorically clear that unless a proper clarification is given, the query raised by would not be answered. Astonishing you refrain from giving proper clarification. Then, my lord, talk about malafide action. We can ignore that. Then kindly come to my lord, next page 331. Third last paragraph, be that as I'm still unaware, this is only relevant portion. Be that as it may, I am still unaware as to what the matter is and for what purpose we have issued the letter dated 24th October 2024. It is prudent that one should at least be informed before such steps are taken, specifically when you ask a former president to appear before a members relationship committee. No reply has been issued to me informing me the matter in question. These are intimidating tactics questions were raised by the undersigned previous AGM in front of various members, which probably made the then committee uncomfortable. Most of the earlier present committee members, well as except induction of one new face. Then, my lord, kindly come to. So this meeting, my lord, was held finally, my lord, on the 8th of November. That is not. Now, my lord, kindly come to 332. 8th November and notice of the meeting was held, my lord, on 8th November. That will be, my lord, evident from 332. Again, my lord, see secretary, then CC members relationship in furtherance to your meeting. Lord, has that, my lord, in furtherance to your meeting when the members relationship committee on 8th November 2024, wherein you have confirmed signing and circulating the undated letter through your WhatsApp to the members at large of our club about 4 to 5 days prior to the annual gen meeting held on 28th September 2024. And as desired by the MRC seeks clarification of the following queries from you. Now, very important, it says the MRC seeks clarification of the following queries from you. Now, no minutes have been given of this meeting. There was only a video recording which was done. And I'm saying that because, a lot of correspondence, me asking for minutes, they're saying, no, the video, now you treat the video recording. Then what we have done, we have given a transcript of the entire video recording. I at least did not find, where, these questions were framed. Then, they say, A, you have made a mass announcement that there have been significant financial irregularities within the club. Please explain. B, you have chosen to send an unnamed and undated letter on a plain white paper with only your signature to members of the club with your assumptions without any prior clarification of fact. Being a past president, what was the purpose of sending such unprofessional communication in this matter, knowing very well how it can tarnish the goodwill and demean the reputation of institution? Please explain. C, your action has caused unprecedented and unwanted speculation and has attacked the integrity of the committee. Please explain your views on the same. Then 2, your good self being a former president of this club, 20th September, president of this club, should not have, without verifying the true and correct facts from any of the committee members, made false and frivolous allegations of financial irregularities and said undated letter. The said undated letter signed and circulated admittedly by in social media was an intent to provoke the members of the club and have caused loss to the dignity of the club and the members of the committee. Further, as requested by you, video recording the meeting dated 8th November 2024 with the MRC is attached herewith for your records. Your request to respond to the aforesaid query is raised by an MRC within 7 days of receipt of this letter email. Now, my lord, kindly come to 2 things, my lord, I want, my lord, to just, my lord, see at this moment. One, আচ্ছা আর অন্য এটার হলো 3 কত বলে 3 now my lord I am sorry my lord I'll just take my lord to the transcript of this meeting which my lord we submitted later on my lord of 8th November 2024 which is at my lord page 452 volume 4 So this is a transcript. No minutes, my lord, official minutes, my lord, were given in spite of my several repeated requests hereafter I'll show. But I just want to show, my lord, what has, my lord, transpired. And, my lord, there's no dispute, my lord, so far as, my lord, this transcription is concerned. And in fact, I think, my lord, at some point they only relied on this to, my lord. It starts, my lord. Second, no, it is not known to me. I've been asking about the, thank you. The reasons we are here is known to you. I said, no, it is not known to me. I've been asking about this in my last 3 letters. Why I have been called, I've never told anything. I was never told anything. I think I was intimated to you with regard to your letter, which you have written to all permanent members of clubs prior to 18. It has been there before. It is in that context we have called you. If you've taken the first letter of certificate which came to me, that was on 9th. That was on 9th. Yes, please note that the undersigned received copy of the letter circular on WhatsApp 4 to 5 days before the AGM from one of the members of the club. The same has come to notice of the undersigned. So undersigned secretary, same has been issued under your signature. Then, my lord, kindly come to my lord, page 454. Uh, 454 in the middle. Mr. Mahesh Punjabi, my lord, asked us, sir, our intention was not even to call you, sir. Maybe the letter was. Normally, the communication goes through the secretary. Fair enough. Your point is well taken. Because, my lord, I was complaining why the secretary is written to me and not so much. But it has gone with our instruction. The only point we want to understand is this letter. In this letter, is this letter which is written, sir? Let me finish. Is it been written by you or not, sir? Nothing else. Then I say, I've sent it by my phone. I've sent it by my mobile. So you are saying you have written that? No. See, this is the situation. Last year before AGM, when a different committee was there, I have sent it from my own mobile. It is not that somebody sent it somewhere. Fair enough. That's all. Then these questions were raised by us. These questions were raised by us by 3-4 us in Indian, which was very usually answered by him. Rightly or wrongly, I'm not aware, but he has done a very good job. That's what I say. So where is the question of him asking me? He could have anybody of you could have called me and I said, I've written it. Sir, you try to appreciate the situation. This is why it is pinching a lot. So you try to appreciate. This is why he's saying received from one of the members. So tomorrow, if I tell him Mr. Maheshwan is giving ABCD, he will on its own go. Then I was told, sir, to answer this question of you, this letter was not on your letterhead and it didn't have your name. It had your signature, which was definitely your signature. And you are correctly saying that it was from your mobile. So just to show that this letter has some language which was not good taste. And it had it was demeaning the committee. So we felt that as you felt that somebody is writing a letter, you're a past president, very respected past president. So when you're writing a language like a significant financial being done, I mean, there has to be some, whether you allow it or not, like you should not have written this. Then, my lord, again, he says something. Then at page 460,
nobody asked me any
in the middle, see, nobody asked me any question except whether it is my signature or not. Now, I'm not prepared to answer what I don't know, what you will ask. So you give me a question, I will give you a written reply so that everything is in paper and pen. Correct. After you've given me this question, you'll give it to me, give some time. Then tomorrow I'm going out, back on the 13th, all that, my lord, is not relevant. Then kindly come to 461.
Who is the chairman? There is nothing we are discussing. First, we want to
in the last 4 or 5 entries, my lord. So there is nothing we are discussing. My lord has one of the membership committee members. This is nothing We are discussing, firstly, we wanted confirmation that whether you have written the letter. You said yes. This is more the scope of inquiry, it seems, whether I've written the letter or not. Then, my lord, this goes on 462. My lord, kindly see, my lord, Bajoria and Surana, you just said that you still don't know what is so wrong and what you've written wrongly. No, I never said so. I said why I am called for. I don't know the purpose. If I'm asked to appear, I must know what I've wrong done and what are the remedies to be. Okay, both have to be told to me. Then Bajoria says, no, I appreciate that. All trying to say is that why you were being called for, whether it was right way or not, I'm not going there. You could have your expectation. Someone would have called you, or the secretary has powers or does not have the power. Those are all you know. I would say personally, I'm going there. I'm not going to the protocol directly. I'm saying first thing which secretary said was that. Then, my lord, kindly skip over the next. Come to 463. Again, Bajoria says the last portion. As I said, he has written a letter. This is, my lord, again on the secretary aspect. 466. Then, my lord, 464, 465, going on with regard to the secretary, whether the secretary should have written or not. Then 466. Starts with, my lord, I've been elected permanent member of the club for the life of my exceptional services. That is, my lord, if you're ex-president, that's what happens, right? If that is what one hand, it is like giving me Padma Bhushan by the government of India, and then whatever, my lord, that language is. So even Donald Trump was impeached, he was impeached, president, so all this goes on. Then, my lord, again, my lord, the last portion is answerable to secretary issue. Then 467. Last 3 entries, one of these Punjabi. There was a language in that committee, in that letter, which was not well taken because it hurts the sentiments of the committee. I don't know, my lord, whether. So all we want to understand that firstly, step by step, you have written this, yes or no. If there can be two answers, yes or no. So you're saying yes, fine. I said I shall not open my mouth. In Punjabi, now we have to tell the committee, the main committee, that this is what has happened. We will give you the letter, we will give you the minutes and everything, and whatever the next step is, we know that when we can. Then, my lord, 468.
There is no question now.
The second entry, sir, there is no question now. There was only one question, if you have written this letter or not. Then, my lord, will kindly come to 469. This is very important. 460 in the middle. Bajoria says, I am confirming that, sir, because you raised all these issues in the AGM and it got passed on to unanimously.
What does that mean?
Because the accounts got passed and, my lord, I raised the issues. So, and perhaps, my lord, saying that though you raised the issues, it got passed. I'm not very sure, my lord, whether, my lord, what it means, but this, my lord, says you raised all these issues in the AGM, which I was entitled to. And it got passed on to unanimously. Then, my lord, this.
Wrapping up.
My lord, kindly come to 469, then 470 on question of votes, my lord, that is not relevant. Then kindly come to 472.
From Contempt. Basically, there is.
Says I must get the question, because basically that will sum it up. You get the question, then in the middle we'll get your reply. Put up the committee will think of putting a question. They may or may not. Probably he said he'll put up to the committee. Then the committee will put the question. So I take it the committee will put the question. Then he says, no, we have not placed this before the committee as yet. There might be an error of a statement. Committee has not even met. So this is very important. There may be an error of a statement. The committee has not even met. So once the committee meets, this will be placed before the full committee, that such is the outcome. The minutes of this meeting will be placed before the committee. And then whatever is the final call, it will be taken at the committee, and the same shall also be intimated to you, prior to which minutes of the meeting shall also be intimated to you. Very good. You'll communicate to me. I'll give an answer. There's no thank you. Now, my lord, so this is the minutes, my lord. Now, or rather minutes, or this is, my lord, the transcript, because there are no minutes. Now, just read this, my lord, with, my lord, page 332 once again. I'm so sorry, my lord. Page 332. I just showed this, my lord, 18 November. It says, in furtherance to your meeting with the Membership Relationship Committee on 8 November, which is, my lord, the transcript, when you have confirmed signing and circulating the undated letter through your WhatsApp to the members at large of our club about 4 to 5 days prior to the annual general meeting held on 20th, and as desired by you, the MRC seeks clarification of the following queries from me. So first of all, my lord, the MRC, on the basis of this transcript, no questions framed. They, in fact, they say we'll put it to the committee, the minutes. Which obviously, my lord, has not happened. And nothing is still now told to me as to why I appeared before the MRC, what are the charges. And that also, my lord, very important. In this also, my lord, in this letter, because this is, my lord, what goes on this 332, it is not said that if this is not satisfactory, or then the committee will decide to suspend you, expel you, because, my lord, there's an automatic, if you're suspended, then, my lord, automatically you get expelled. And, my lord, will recall that's why, my lord, passed an order, an interim order, my lord. So on there, really, my lord, both of us came, and that interim order saying, my lord, that the expulsion should not, my lord, happen because of the lapse of, my lord, period, lapse of time. So this is, my lord, where we stand. Now kindly look at, my lord, one more thing. In the supplementary, my lord, which we have handed over. Oh, sorry, it minutes to notes minutes. My lord, in the written notes, my lord, page 28 is the minutes of the annual general meeting, which was handed over to us, my lord, at the time, my lord, when, my lord, the hearing was going on.
Yes.
My lord, of, my lord, 28 September 2024. This is, my lord, the subject AGM, where, my lord, before that, where I had circulated. Kindly see minutes of annual general meeting held on Saturday, 20th September. Meeting was attended by 156 permanent members. Following of the committee were present. Then, my lord, meeting number 1, not then meeting number 2. Then, my lord, kindly come to page 29. Minute number 3, opening address. Then kindly come to page 31. Minute number 5, agenda number 3. Adoption and passing of the account of the 12th month period ending 31st March 2024. Chairman informed the House that there were questions received from 3 members on accounts related issues. The chairman, Mr. Siddharth Junwala, invited Mr. Rishi Bajoria, the chairman, finance, to clarify the observation raised by the following members. Then, my lord, someone else member raised 3 observations as under. Bhandari was invited by the chairman to read out his letter. We had inquired about the reason for new head. My lord recalls, my lord, in the minutes. Expenses for children, sports and club events, and the reason why the same was not reflected in the previous year accounts. In his second query, observed that the audited figures for the Provident Fund, Pension Fund found to be amended, and why the same were not finalized by the auditors, although they had sufficient time to do so. He also pointed out that for reasons for variation of the figures under the heading Other Expenses compared to the previous year, to reply from Mr. Rishi Bajoria, Chairman, Finance of Queries, answer. Chairman, Finance desired to reply to all 3 questions collectively as they pertain to reclassification accounts, heads and members in the balance sheet. Now, my lord, I must point out in the rules, the 30 days. My lord, in the rules, it says if there something like this correction has to be done, it is to be done, my lord, within 30 days. 3 months. Sorry, 3 months. 3 months. Sorry, my lord, 3 months. So, my lord, from the previous figure, my lord, if there was something, had to be done, my lord, within 3 months. The chairman desired to reply. The chairman finance told the members that there had been a small typo error where a comma has been missed in the ledger heading, which should rightly have read as expenses for children events, comma, sports event and club events net. To elaborate, there were 3 heads of events merged into one, as 2 of them are insignificant, small in number. Currently, that the auditor advises to merge the same. Clarified inclusion of those headings in the comparative figures were done to ensure consistency ease of comparison between the 2 years. While the specific head was not listed separately in last year's financials, expenses related to children's sports and club events were accounted for under broader categories of other income. So where is all this explanation? It's coming here, not in the balance sheet. The balance sheet should have ideally had this explanation. The figure of classification relevant under new. As for the current year, total expense of rupees 2.02 crores under this head included all costs relating to organizing and facilitating children's events, sports events and club events. Details of expenditure rupees 2.20 crores were provided satisfaction Kamal Bhandari. To address the other concerns of Kamal Bhandari, the chairman finance stated adjustment made to the figures were the result of classification, which became necessary to ensure accurate representation accounts. While the audited accounts for 22-23 were signed at the end of August 23, need for these reclassifications only came to light during the detailed analysis conducted in the preparation for the current year's financial statements. Then next is very important. The chairman finance further stated that in hindsight, had these issues been identified earlier, they would have been incorporated in the last year's balance sheet before the committee and auditor signing of the same. However, the nature of these reclassification was such that they become evident only after further review, and thus had to be reflected in this year's comparative figures to maintain transparent consistency across financial periods. Summarized, Chairman Finance further stated that none of the classification changed the end result of our income and expenditure balance sheet, so done as per permissible accounting standards suggested duly approved by our auditors. Then Malad Goenka was also requested to take up the letter. Then Goenka was desirous of an explanation in respect of the capital expenses reflected in the accounts, though the same was notified in the previous year accounts. He inquired that since part of this expenditure was not shown as work in progress, and whether this work was commended in haste. His further query being the reason as to why the club's overall funds by way of investment and cash in bank has shown a mere increase of 2.80 crores, despite the club having received 12.175 crores by way of entrance, administration and development fee. Bajoria explained that the bulk of the receipts were invested in development work undertaken and the balance was utilized in making statutory liability as well as on low-risk capital investments. Then the reason for hasty decision having major impact on class financial, Chairman Finance clearly stated no hasty decision has been taken, neither had it made any negative impact on the club financials. If there were any impact, it was surely positive one. Chairman Finance apprised the members committee after due review and discussions had finalized on some important projects for the upliftment and development of the club and managed to execute them in record time during the same year. This was rather a reason to applaud the president team for outstanding performance. Then question 2, details of such capital expenditure. Chairman Finance said details of the entire capital expenditure were available, recorded in the club's book of accounts, and the balance sheet had broad details of all capital expenditure, which Mr. Goenka had broken down in his question. Chairman Finance gave a further breakdown to give members more clarity. Then quotation taken from vendor who were entrusted the work. Chairman Finance stated that all necessary proposals and procedures, including quotation from various vendors and approval by committee, were followed. Well, I will recall, my lord, we had raised an issue as well because it's all being discussed. Approval and authorization by subcommittee and committee. Chairman further emphasized all approvals have been taken from the committee for all works that have been executed. Same were duly minuted. There was also a letter on accounts. Mr. Surana request to take up the question. There was also a letter on accounts. Mr. Surana requested to take up the question under agenda number 5, which was agreed upon by the chairman. Chairman requested a proposer, took up the resolution for the approval of the House. Same was duly proposed by Manoj Bhagat. Second, accounts financial were adopted unanimously. Then, Malad, minute number 6, agenda 4 to re-elect. That is, Malad, not. Then kindly see page 36. So my query, Malad, because the other queries, Malad, were similar to Malad, what queries I had also raised in my WhatsApp message. Then my queries, further queries, remaining queries also taken up. Chairman requested Mr. Sansas to take up Surana's request. Query as it pertains to finances. Question, Mr. Jai Surana query inquired how much money was spent to renovate the men's changing room and bar number 1. He also asked whether any quotations were taken before the start of the work. If yes, from how many vendors? Was it not prudent to inform members before spending such huge amount on renovation? He also asked, was it also not prudent to circulate to all the members major heads on which his expenses were made? Answer, the amount spent on the men's changing room was 1.35 crores. Amount spent on bar number 1 was 2.73 crores plus applicable statutory. Yes, quotations were taken from multiple vendors as and when required. Bajori also reiterated that this whole renovation process was kick-started by you and you in your tenure as president. And you will recall that even at the stage, you have not followed what you mentioned later. So we are following your footsteps.
Yes, but his grievance regarding the irregularity in the accounts was not addressed at the AGM.
Malad, those Malad figures which Malad this gentleman Malad who raised it, part of it Malad was Bhandari Malad raised it at page 31.
One or two items.
One or two or Malad. What was raised, Malad, that was the ones, Malad, which were expenses for children's sports and club events,
yes.
Then provident fund, pension fund, other expenses. And Malad, that capital expenditure, Malad, has seen that went up considerably, Malad, from 1.35, which was in negative, other income, became Malad positive to 55 lakhs. So, Malad, this is the minutes. And then, Malad, page 37 is one of the other agendas, and 38 ends, Malad, with a vote of thanks. Now, Malad, what I'm on is, as a member in a club, as a shareholder in a company, you are entitled to, as part of your membership, to raise questions. And you are to raise it before the Gen meeting where the accounts are to be adopted. You have raised it by ensuring that everyone has it. The questions are also dealt with in the AGM. Then, and if I put my Malad argument to question, what survives? You can't then go on a witch hunt to say now, because this is what has happened, to ensure that now no one ever raises any questions or any issues in respect of the committee. Otherwise, the committee will come and ensure that you're thrown out of the club. Because here the suspension in terms of the rules ultimately leads to expulsion. So, my lord, our submission before my lord is there, first of all, my lord, have I committed something which requires or which will lead on the face of it to say that, my lord, we have said anything against the interest of the members of the club? It's not only the committee, it's also the members. Everyone must know what is happening. Second of all, after having addressed, because then the question should have been First thing would have been to say, I'm sorry, absolutely frivolous, you have circulated, and this should have been brought up in the Gen meeting. This should have been brought up in the Gen meeting, Mr. The plaintiff should have been told that I'm sorry, we found that you have circulated this. Why have you circulated this? Because the pre-general meeting issue. You do not do that. You quietly answer whatever has to be answered. All questions may not have been answered, but you answer at least some of the questions to the best of your ability. And then to pursue by the same committee and to say we suspend you is something which what we are really aggrieved by. So this is the minutes of the Gen meeting. I've shown the transcript of what happened on 8th November in that membership committee. And now we get that letter which all of a sudden poses 3 questions, which says that the membership committee apparently has framed this question, which is also not correct. Now, I'm sorry, kindly come to 332 I have shown. This is coming back to volume 3. Kindly come to 334. We say kindly refer to email dated 18 November. I've shown that that email which I've, as promised in the meeting held with MRC on 8 November, the minutes of the meeting is yet to be forwarded to me. You're requested to forward the name to me. The minute the same to me. The same to me to enable me to answer the queries raised. Then 335.
Same is not what has been.
That the D should be read as S. Loud voice, I didn't want to say that.
Yes.
I'm sorry, that should be corrected as SAME. 335. Please refer to your mail dated November. This is again from the secretary concerning your demand for the minutes of the meeting dated 8th November. As you were informed, now can you see the change of stance which they take? As you were informed before the start of the meeting that the secretary is not available due to health reasons, entire proceeding were being videographed to treat it as the minutes of the said proceeding, for which you had also concurred. Pursuant thereto, questions have been formed by the members relationship committee. Again, not correct, and the same have been sent to you with the entire video clipping. Please note that no separate minutes of this meeting held on 8th November, and as such, your request to give reply to the question on the members relationship committee sent to you within 7 days. Now, 2 objections. First of all, the transcript itself said that minutes will be done and minutes will be placed before the committee. It also said it will be given to me. The rules also require minutes have to be done. Because you videograph,
yes,
doesn't mean there won't be any minutes. Videograph can be edited. So the sanctity of something to be in writing to show that what is your stand really on this minutes or on this meeting. Then 337. My response is there. In the middle, with reference to paragraph 2, the same is denied and disputed. Simplicity, the chairman of the meeting, Mr. Sansad, asked me whether the entire meeting be videographed, to which I proposal readily agreed with the condition that the entire unedited footage be made available to me within a day or 2, which was accepted. It was never discussed that videograph of the meeting be treated as the minutes of the said proceeding, and hence my concurrence to the same cannot and does not arise at all. I only concurred for the videography of the entire meeting and nothing more or less. This proposition that the video footage be treated as the minutes of the meeting is an absolute bizarre proposition, unheard of. Then 3, with reference to paragraph 3, a denied dispute, same in totality. Kindly go through the last 2 minutes of the video footage. Kindly hear what Mr. Rahul Singh has said, which will speak for itself. Immediately thereafter, the meeting was closed. Then, Lord, I talk about my last paragraph of that. In the aforesaid facts and circumstances, request you to send me the copy of the minutes placed before the committee. Very important, placed before the committee. Copy whereof was promised to be made available to me before I take any further steps. Now, this, unfortunately, this goes on back and forth. Then, 339 is 4th December. MRC, this again from the secretary, from the club.
Mr. Banerjee, it'll take some time so we can release your other friends.
Yes, yes,
All other matters released.
Malad, 339. Malad, MRC in receipt of your email dated 27 November, noted the contents thereof, noted the contents mentioned therein, contents on the email sent by the undersigned 25 are true and correct. Upon instruction received from MRC, undersigned once again reiterates there are no separate minutes for the meeting held on 8th November, and the videography sent to you is being treated as the minutes of the meeting held on that day. Same was also placed before the executive committee for their comments and consideration. I really do not know what kind of procedure this is. Hence, you are requested to reply to the questionnaire sent to an instruction to MRC on 25th November through email dated 25th through email within 3 working days hereof. Then 340 8th December.
This goes on and on, Mr.
This goes on and on.
Yes.
So, 340, 341. Again, them, they reiterate, this is unedited version. Reply. Then, 342, they wanted, the committee, they wanted me to present before the committee. Where I was not there, then the date gets extended. Then kindly come to 344. That's the point. 344. Well, this is 17 December 2024. Upon instructions received from the members relationship committee. Now, very important. The members relationship committee ended with that 8th November. And they said, we have nothing further to do. We will give the minutes to the committee. But it seems the secretary goes on writing on this members relationship committee. Questions were also not framed. The secretary said this was framed by the members relationship committee. Then they say, upon instructions received from the members relationship committee, please note that you have failed and neglected reply to the questionnaire raised by the MRC in spite of several requests and reminders served upon you. In the premises, you are requested to meet the executive committee in the committee meeting scheduled to be held on 20th December 2024 at 7:30 answers with your answers. Then 17, we were not there. We had given an earlier letter saying we are not there. Then this was scheduled to on 27 January 2025. This will find at page 345. Now kindly come to 346. This letter and the next is of some relevance, which I would just request I'm going to So I appeared on 27 January. This is to put on record, this is my letter after I've appeared before the committee. This is to put on record that my email dated 18 January, the committee had requested me to appear before the committee at 17:30, 27 January. And upon my request, President also allowed one former president of the club, Mr. Sansar, to accompany me. No sooner the meeting started, President asked me whether the answers as sought by the membership relationship committee, which was forwarded to me on 18 November, is ready or not. In this regard, I categorically stated that in the meeting held on 8 November by the members relationship committee, which was videographed, I have all along been asked to provide me a copy of the minutes of the meeting, which was to be prepared for the perusal of the committee, based on which the committee will decide the future course of action, and a copy of the said minutes will also forward it to me. No sooner it is prepared and will also be placed before the committee. In spite of repeated requests through various emails by me, the minutes of the meeting held on dated 8 November was never forwarded to me for reasons unknown to me. Instead, it was communicated to me that the video of the meeting we treated as the minutes of the meeting. My stand all along has been that until and unless the minutes of the meeting as promised is not provided, it will not be possible for me to answer the questions raised by the MRC, which in fact was told to me in the MRC meeting. The committee will take a call. Whether to put the question or not was to be put forward by the committee. Now, this is correct because that is what was happened on 8 November, the transcript which I've shown. For that very reason, I kept on insisting that the video be played at least from 1930 minutes. Mr. Rahul Singh made the assertion, communicate both the committee. Then 347, paragraph 5, both members of the committee and I struck to a point of view where the committee told me videograph the meeting held on 8 November treated as the minutes of the meeting. I kept on insisting videograph can never be treated as minutes of the meeting, written minutes and such, taken further steps. When this interaction was underway, Mr. Dani, a farmer, to intervene and asked me a question whether my WhatsApp message, which was circulated to members of the club prior to the AGM, which included the word significant financial arrangement, was meant that the committee members have been siphoning the funds. To this question, I immediately replied that I never meant that. And I categorically stated that the irregularities were in the manner in which the accounts of the club are maintained and audited, and that in the balance sheet for the years ended 23-24, more than 20 corrections have been made for the accounts which were already approved and passed a year back for the year 22-23. Such irregularities were sought to be highlighted and was highlighted in AGM of the club held on 28th January. I further stated, 20th September. I further stated in the said AGM, I vehemently propose that the auditor be changed. And since the turnover of the club is now in crores, the best possible auditors be appointed so that such irregularities do not crop up again. Present members of the committee can check the minutes of the last AGM whether I proposed the same or not. Then 7. Further, I had also proposed that in case the committee has misunderstood the meaning of financial irregularity, I can again write to all the members stating exactly what I meant by such statement. This proposal was not accepted by the committee, and the committee only wanted answers in writing without providing me the written minutes of the meeting, which was promised in the MRC held on 8 November. Then during such the paragraph 8, during such argument, one committee asserted term financial irregularity meant that it was the members of the committee who had committed the financial burglary, to which I reiterated I had casted no aspersion of financial burglary in any of the members of the committee of the preceding year, purely meant irregularity in the manner in which the accounts of a club was audited by then chartered account appointed by the club. Then 9, present committee should appreciate that had I, along with other members, not raised pertinent financial question AGM for the year 22-23, this process of irregularity would not have undertaken, which according to Rishi Bajoria was reclarification, rather putting a form of scrutiny up to a first and forensic audit. Then 10. Thirdly, during the interaction, members of the committee, secretary started pointing fingers at me, shouted at me, strongly objected. None of the committee members, including Sansar. Then kindly see next page, 348. The meeting concluded on the point that the president kept on insisting that I give the answers to the queries raised by the MRC, whereas it was the committee which was to send queries to me after perusal of the minutes of the meeting held on 8 November 2024, as was stated in the said meeting. But since the questions came from MRC, which became functus officio on 8 November itself, which would be evident if the video footage of the meeting of the MRC is seen, and hence I kept on insisting video footage be seen, but none of you present even be bothered to look into the same, as what you were doing was contrary what was agreed. Reference made to Night's answers. Why I insisted on writing minutes and no contrary stand. 12. Therefore, since the committee was adamant treating the video of the MRC meeting as the minutes, never questioned if you advocate in the committee whether the video can be censored. Since there was no consensus in the meeting, 13, meeting was concluded by stating the minutes of the meeting held on 27 January 2025 will be shared with me. The committee reiterated that video footage of the MRC meeting will be treated as the minutes of the meeting. At the end, the question was put to me whether I'll be answering the queries in 3 days or not, to which I stated that once the written minutes of the meeting held on 8th November 2021 provided, I shall do the needful. So this is, my lord, according to us, my lord, what transpired on 27 January 2025 in the committee meeting. In the executive committee meeting, not, my lord, membership. Membership is 8th November. Where no questions framed, they say minutes will be placed before the executive committee, they will frame questions. Then, my lord, we had those questions and I insisted on, my lord, video. Now, my lord, kindly see the suspension, my lord, which comes at page 349. Prior to the annual general meeting, of the club scheduled to be held on 20th September 2024. A letter in the form of a circular was circulated amongst the members of the club in large under your signature, wherein certain allegations where serious financial irregularities within the club were made. And it was also alleged in the said letter circular, the serious financial irregularities have been identified by you, as would appear from the said letter. The tenor of the letter was to scandalize and create fear of commissioning of wrong by the club committee relating to spending on building, furniture and fixtures, investments which have come down, thus hinting dishonesty and misconduct by the committee members. Allegations made in the said letter affected the reputation, goodwill and good name of our club and cast a doubt on the integrity, honesty and clarity maintained by the executive committee and the club towards its members and caused irreparable loss, prejudice and injury to the club. Club, through its secretary, with a mail dated 9th October, first sought a clarification. Then, my lord, this goes on. Just stopping here for a moment, my lord, just, my lord, pausing here for a moment. Paragraphs 1, 2 and 3. My lord, no one complained in the AGM that this was the effect of my letter. No one raised this issue. That would have been minuted then. If this was of such significance, committee itself should have said that you, Mr. Such and such, what do you mean by writing this letter? You have cast aspersions on us. So this is ignored. And post factum, my lord, after I have not done anything, my lord, after the Gen meeting, all this comes up. Then, my lord, sees 4, club through its secretary with a letter 9th October, first sort of clarification, confirm whether undated, then my lord, this narration happens. Then, my lord, 6. The executive committee thereafter, in view of the allegation of significant financial irregularities with respect to the club's money and assets so made in the said letter, cast a serious dent on the reputation of the club in the eyes of the esteemed members of the club, sought to make an inquiry by referring to the matter to members' relationship committee, with instructions to make inquiry and report to the committee. 8 November 2024, 18 p.m. you appeared before the MRC, when first informed that the entire proceeding videographed, same will be treated as minutes, record of the said meeting, on was not present, such. Thereafter, same you admitted. This one goes on. Next page, kindly see. Paragraph 7. However, in the meeting, you refused to reveal any basis on which you issued the said letter, circular letter, and also definitely refused to answer and to give any details on the material on the basis of which the scandalous charges were made by you. You also stated you would not answer or give an explanation meeting, answer the question. Whereas the questions put to me, paragraph 7.
We've gone through this letter. Show us the rules now.
Yes, my lord. My lord has seen, my lord. My lord has seen, my lord. Paragraph 12, my lord has seen.
Yes, yes.
Not drawing inference.
Unparliamentary language.
Yes, then considering that, then 14, my lord says, considering the scandalous allegation, charges made in letter circular is demeaned. Then, my lord, the 15 they say under Rule 22B2 of the club's rules, you from the user club period of 3 months and call upon you to resign from the club as a member under clause 22B3. Now, my lord, kindly come to the rules, which my lord will find, my lord, at page 75. This should be, my lord, volume 175.
Volume.
Oh, sorry, volume 2. I'm so sorry.
175 is the relevant.
No, 175. No, 75 থেকে শুরু হয়েছে। আরে কি বলছো?
Starts at 147 and goes on to
আমি ভুলে গেছি। 147, which is volume 1. Yeah, yeah. My lord, rule. First, my lord, I just want to show my lord, just one or rule 17. My lord, rule 17.
Hey, এতে কিচ্ছু নেই।
Volume 2 টা so sorry. Sorry, my lord, by mistake.
এরপরেরটা দাও, এরপরেরটা। 17.
Permanent member টা কোথা বলছে? Ex-president permanent member. Yes, my lord, 17, my lord, talks about a honorary permanent member. Ex-president honorary permanent member. Huh? That is, my lord, not because my lord, he becomes, my lord, a honorary permanent member. That's not. Kindly come to my lord 22 straight away. Rule 22, page 175. (22)(b). It shall be, if it shall be alleged that any member of the club has committed a grave breach of any rule or bylaws, or has been guilty of or responsible for any conduct, act, or omission, whether within or outside the club, or has been guilty of or responsible for any conduct, act, or omission, whether within or outside the club, such as to affect the character or good name of the club, or to cause annoyance to other members, or if the committee satisfies a member or any relation of a member enjoying the club facilities under responsible member has given any monies, gratuity, or other investments, the committee may request such member to appear before them at such date, time, and place as may be specified. And if the member shall then fail to appear as requested or appearing shall fail to give explanation acceptable to the committee for the matter alleged, committee shall have the power to, 1, to caution or reprimand such member. And then 2 is to suspend such member from the use of the club for any period not exceeding 3 months. Then where a member is suspended is above, to call upon such member to resign from the club. So, my lord, either I have to commit, my lord, a grave breach of any rule or bylaws, or responsible of any guilty of responsible for any conduct which will cause which will affect the character or good name of the club. This is, my lord, the charging, my lord, or my lord, the relevant words, my lord, so far as 22B is concerned, for me to come under this. Now, my lord, kindly, my lord, appreciate that, my lord, in the after this, in the Gen meeting or anywhere else, it is not their case anyone else has complained. The first notice is issued to me by the secretary. 9th October 2024 is the initiation of this whole thing on the basis of the CEO's or the secretary's letter. And under whose authority or sanction, we do not know. Because that is the first response I had given, saying, under whose authority have you said this? It can't surely be the secretary's complaint, because that's not what he says. And he wanted to know only, my lord, whether I've written that, signed that letter or not. Then when I question his authority, he says now membership committee has been constituted. Members relationship committee. That is the meeting on 8th November. No minutes given, results Malad in 27 January 2025 meeting of the executive, and Malad I am suspended on 30th January. Now Malad, kindly see Malad, now after this the rules C is very Malad dangerous, because what happens is, if having called upon to resign as above, member concerned shall not do so at 176. Member shall not do so within 24 hours. Thereafter, the committee may refer the matter to the specified board for decision as to expulsion or otherwise of the member. Then a special board in such cases shall be considered as follows. Then Malad, these steps follow. Malad, there is a particular time limit which Malad has now stated, so that Malad, this doesn't lapse, or Malad, this doesn't go against me. Now, their case was, Malad, before the first court, oh, nothing has happened. You go to the special board. And there it will be decided. We said, no, sorry, you have suspended me. To come to the special board, first you have to show your suspension is correct. That you have 22B has been correctly invoked, 22B, 2 and 3 have been correctly invoked, or the procedure followed for you to come to this stage. Then, Malad, just 3 or more Malad, rules. Kindly see, Malad, rule 42H at Malad, page 189. Is Malad the appointment of a subcommittee. To appoint subcommittee special purpose, consider such members of the club, whether members of the club or committee or not, as they may think fit, delegate such committees on the powers, such are the powers as may seem fit, any subcommittee so appointed shall answer. Malad, we also do not know under what Malad, which is the minutes, how they were appointed. We do not know all that. Then Malad, kindly look at 46, rule 46, 191. Very important. All audited accounts, when passed by a general committee, general meeting, the smaller 2023 accounts, shall be conclusive, except as regards any error discovered therein within 3 months after passing. Whenever any such error is discovered within that period, the account shall forthwith be corrected, and henceforth shall be conclusive. And now, Malad, kindly look at 51 at page 194. Page rule 51 to 193. 193, sorry, 193. It requires minutes of and the resolution passed at each meeting of the committee, and such general meeting of the committee shall be fairly copied in book and signed by the secretary, chairman each meeting. Minutes of the annual general shall be open to inspection by all members for 1 month from date of such meeting.
To what extent can the court interfere with the club's internal affairs? To what extent?
Yes.
Address that issue also. In your own time, address that issue.
Well, to the extent that because otherwise, Malad, there is no, it's not that Malad, the club committee members can run amok. Malad, they cannot just do whatever they want to do. Yes, the court's power is limited. Because it's a social club, it's limited. But that would not mean, Malad, I understand, Malad, in a gen meeting, Malad, there's a vote. Majority votes that this member should go. Some clubs, Malad, have that provision to remove, Malad, someone, Malad, from the... So, that is different. But when, Malad, it is restricted to people against whom I make such charges or I raise questions, and those very same people will immediately say, sorry, you cannot even raise questions, because my lord also has to see what have I done. Today, my lord, it could be as silly as or irrelevant as saying, oh, I smiled at or I laughed at one member.
Show us the case law.
Yes, my lord. There are cases, my lord.
Because if you don't like the club, go away.
My lord,
if you don't like the manner in which the club is being run by bad people who won't tolerate questioning, can you do much? This is what I said. Show us
correct. My lord, is absolutely
extent of power.
My lord, I am only, my lord, joining issue to say that it can't be only at the whims and fancies of the committee members. Today, if I have a right, because I am also a member, my lord is taking away my right as a member. The club is taking away my right as a member of a social club. Some are incorporated, my lord. This is not, my lord, a incorporated club. Where, my lord, it's a private limited company. It's like, my lord, a membership.
What are the prayers in your suit? You have claimed damages also.
My lord, in the suit, no, I will just check on that. I don't.
If a valuable right is being illegally taken away, you may be compensated in money.
Page 359, my lord, no, my lord, my right is to, my lord, participate and, my lord, be a member of the club. Three. My lord, I'll just show, my lord, the.
Must be injunction declaration.
Yes, right. It should be, my lord. I don't immediately remember, my lord, what 421. Sorry, my lord, volume 3. I just read it out, my lord. Doesn't have to, my lord. Yes.
Only page 139 is set out as it.
I'm sorry, I'm the 420. My lord, I'll just read it out, my lord. Decree that the notice of suspension dated 30th January, notice 6th February, on any further notice were judged illegal, null and void. Decree for deliverable and cancellation. Permanent injunction is indifferent, giving any effect or further effect to the notice. Then receive an injunction attachment. If it could be quantified in money, my lord, that would have been totally different. What is that? Victoria Lodge. My lord, Masonic Lodge, my lord, is really, my lord, the case, my lord, which. Masonic Lodge, my lord, that's the one, my lord, which says to what extent, my lord, Supreme Court held, my lord, one can, my lord, look into this.
Roughly how long you will take?
My lord, not more than, my lord, half an hour. 20 minutes to half an hour.
Kalke?
Kalke. Huh? No, it's not fixed. কালকে কি সকালে কালকে 11:30টার সময় 11:30 তো আছে না ওই সরকার আর কৃষ্ণ
half an hour.
Lord, only one request, my lord. I have, my lord, matter at 10:30 and 11:30. It will not take much time. 2:30. Very well.
For half an hour.
We will respond tomorrow only, my lord.
This bench tomorrow will be available till 3 o'clock. So on Monday. You will respond on Monday. You can have a peaceful weekend. Hey, Mr. Banerjee, comma learned senior advocate representing the appellant / plaintiff, begins his opening submission but does not conclude. Paragraph List the matter once again. Kalki did the marked 2:30 p.m.
I'm so grateful. I'm extremely grateful.
Hey, Baba. How many volumes do you have?
Well, 4 volumes.
And one supplement.
And one supplementary affidavit.
শোনো মনে করিয়ে দেবে তো ওই অরিজিনাল সাইডে যে